With the permission of the Lordships, we shall now begin the program. Honorable Mr. Justice H.S. Thankyou, Judge, High Court of Meghalaya, and Judge in charge of the Meghalaya State Judicial Academy. Honorable Mr. Justice W. Dingdo, Judge, High Court of Meghalaya. Esteemed judicial officers, police officers, and member of the bar. It is my privilege to welcome you all to this refresher program on the new criminal laws. The Bharatiya Nyaya Sanhita, BNS, the Bharatiya Nagrik Suraksha Sanhita, BNSS, Bharatiya Sakshya Adhiniyam, BSA. This program has been designed to deepen our understanding of these enactments and the practical implication for investigation, prosecution, and adjudication. In addition to the sessions on new criminal laws, I am pleased to inform you that there will also be a special session on sensitization in dealing with cases under Section 304B, IPC Dowry Debt, Section 498A, IPC Cruelty by Husbands and Relative, and the Dowry Prohibition Act 1961. This session is being conducted in line with the direction of the Honorable Supreme Court in State of Uttar Pradesh versus Ajmal Beg and others, 2025, and further reinforced by the Honorable High Court of Meghalaya. I'm delighted to express that we had earlier conducted an orientation program on new criminal laws for the same target group. On that occasion, some of us were fortunate to have the opportunity to interact with the distinguished resource person, Shri E.V. Chandru, Special Prosecutor, NIA, Tamil Nadu, and practicing advocate at the Madras High Court. His insightful guidance during those sessions was deeply appreciated, and we are indeed privileged to welcome him once again to lead us through today's deliberations. For those of you who could not join us during the earlier program and missed the opportunity to meet and interact with Shri E.V. Chandru, allow me to present a brief introduction of our esteemed resource person. Shri E.V. Chandru enrolled as an advocate in the Bar Council of Tamil Nadu and Pondicherry on 30th July 1997. He is deeply committed to advocacy, having rich and vast experience of 28 years. He has been empaneled and appointed as panel advocate for the High Court Legal Services Committee, Chennai, and various other legal services authority, and a panel advocate for the Honorable Madras High Court Lok Adalat. He has been a resource person for Departments of Legal Affairs, Ministry of Law and Justice, New Delhi, National Judicial Academy, Bhopal, various other state judicial academies, and the Sardar Vallabhbhai Patel National Police Academy to address on new criminal laws 2023. He has also delivered lectures in law at various universities and various bar associations. He has been awarded as the project leader in the National Service Scheme in 1990. Best Army Wing Trophy recipient, NCC Cadet Senior Under Officer C certificate holder at Republic Day Camp 1993. Awarded Meritorious Sportsman by the Government of Pondicherry, recipient of West Cadet NCC Army Wing Chief Minister Gold Medal, Pondicherry. BA History winner of TB Nayyar Memorial Gold Medal for Topper in History Department, Pondicherry. Winner of International Duke of Edinburgh Award from Prince Philip's for meritorious exceptional performance in both academics and sports in 1994, and a recipient of the Jagannath Daigo Award for LLB by Pondicherry University. A white notification dated 18/7/2024, the central government has appointed him as a special public prosecutor NIA before NIA Special Court at Pondicherry and the High Court of Madras. With these words, I take the honor of inviting Shri E.V. Chandru to take us through this program today. Sir.
Good morning, my lords. May I start the session, my lords? Yes. Good morning, everybody. Are you all happy today? Why? Because out of court today and out of police station today. Yes, with the blessings of my parents and my teacher and senior advocate, Mrs. Vrinda Mohan, and advocate of Pondicherry, I am in front of you. And Meghalaya has become a hometown for me. I think this is the third or fourth time. So I am grateful to my lords for the gracious invitation and hearty invitation. I am also thankful to the director and deputy director for constantly not leaving me. Even if I say no, they will not leave me. They will call me. And we have elaborately dealt with the new criminal laws last time. So I have designed basically that today we will deal with some of the intricate aspects where the Honorable Supreme Court has given judgments on the issues. Okay. Before that, why these new criminal laws were set into motion and what is the intention of the Parliament of having a new criminal law? What is the intention of the Parliament in having a new criminal law? Anybody? No? Anybody can answer. Usually advocates will answer no. Yes. Why new criminal law came? What has happened to the old criminal laws? Are they not sufficient? Are they not addressing certain issues properly? The Parliament thought it fit that every stakeholder under the new criminal law should have a time frame to give result such that speedy disposal of the case and speedy justice will be delivered to the victim and also the accused. Am I right? Am I right? Yes. So the new criminal law is addressed by the Parliament. What are the aims and objective of the new criminal law? It is for regulating procedures of arrest, investigation, inquiry and trial of offences and fast and efficient justice system. So these words, fast and efficient justice system, I think will not be possible if the police and also the advocates cooperates with the court. I have the courage to say so because I was a defense lawyer for around 26 years. As a defense lawyer, if you want me to speak the truth, if I find that the judge is a conviction, we categorize judges as conviction type judges and acquittal type judges, no? Who gives the certificate that he is a conviction type judge and acquittal type judge? Bench clerk. Right? Suppose I want to conduct a case in Meghalaya tomorrow. What I will do? I will go to the court the day before, interact with some of the advocates there and ask the bench clerk or the court policeman. And if the judge, if at all, has given 2-3 acquittals, then the judge will be branded as what? Acquittal judge. And a case where he has to give a conviction, if by misfortune or good fortune he has given 3 to 4 convictions, then he will be branded as a conviction judge. Right? So I have also been in that all those traps for a very long time. And when I was a defense lawyer, to speak the truth, I will also think that I should not get a conviction. Now I am in the other side of the trade. I am a public prosecutor now. If I feel that a judge is going to let a man on bail, that too in NIA bail, what I am doing? I want to see that it is not listing. I want to take an adjournment to speak from the heart. Right? So, if at all the system has to be very transparent and very efficient, super fast like Vande Bharat train and all, unless advocates and prosecutors cooperate, poor judges cannot do anything. Advocates accept with me? At least judges will accept with me. Judges are in the front row, no? Judges, am I right? Yes. So, cooperation from the police and the prosecutors and the advocates are very, very essential if at all the dream of the Parliament should come true. Okay? So advocates plays a very important role in seeing whether the matter will come to an end or not. Or what we will do, we will file some application, go to the High Court and obtain stay. Right? We all can interact and speak. See, it is getting, only Chandru is getting recorded. If you speak from there, nobody will record. So you can speak truly and boldly today. Yes. So the Parliament wants things to be done super fast. Stakeholders are very important in rendering justice. Yesterday I was coming in a flight. One person from NIT, one person from Delhi IIT, he was traveling with me. He asked me one question, sir, why is the delay is caused in rendering justice? I asked him, who are you? He said, I am going to attend a conference today in Shillong, NIT. Is there any NIT here? There is some conference today in NIT. He said, I am from IIT Delhi, sir. I am attending a conference in Shillong. I truly said, whatever I said, you know, in this stage, I told him also. I said, advocates, police, and litigants are the prime reason for delay. Sometimes judges also. Sometimes. All right. So we should first have a insightfulness as to who is making the delay and how the poor litigants are suffering. Okay. Yes. Then electronic evidence is introduced in the new criminal law. Previously, I was carrying a lot of books with me. Now all books, every book is here. You can have a full library in this gadget. Right? Now electronic evidence is also has to play a very vital role such that after 5 to 10 years, only judge will be in the court. That too, not a huge court like that is not required. He will be sitting in a small room with electronic gadget and clients will be sitting somewhere, advocates will be sitting somewhere. At least petrol, there will not be any fuel expense and there will not be ruckus in the court physically. If you have to shout, you have to shout from the office or from the home. Litigant should shout from the place where he is deposing and judge should speak from the place where he is speaking. So section 530 is one of the greatest dreams of the Parliament, 530 of BNSS. We will just go to BNSS to understand the whole scheme of the Act. What 530 of BNSS says? Yes. Trial and proceedings to be held in electronic mode. All trials, inquiries and proceedings under this Sanhita, see the word used is section 530 of BNSS is the dream of the Parliament which may be extended periodically by the Honorable Courts. Now that few days back the Honorable Supreme Court has sent a communication to all the High Courts on making a complete draft on using artificial intelligence. Have you all seen that? Yes? Police officials, have you seen that? Supreme Court's communication to all the High Court as to how they develop the artificial intelligence to be used in the judicial process. I will circulate it with the director, you can all take that. Okay? Now, trial and proceedings, that means every activity of the court, what precedes in a judicial court, before trial what happens? What is that stage, before the trial stage? Before the trial, there are a lot of stages, no? Bail is there, filing of police custody petition, return of property, return of document, right? Issuance of summons, taking cognizance. After he appears before the court, what happens? 207 proceedings, furnishing free copies, charge framing, discharge. What is all this called? Whether all this comes under the caption of trial? Yes or no? No? When does a trial start then? Supreme Court says trial and other proceedings. When does a trial start? When? After After taking cognizance. After taking cognizance, summons will be issued. After receiving summons, he will be appearing before the court. Then we will give him a dull copy. Then Vakil will say that the copies are not legible, copies are not sufficient. In that year will go. Then after a year, free copies will be given properly. A trial will get commenced only after the charges are framed. Hardeep Singh versus State of Punjab, 2014 Supreme Court, Constitutional Bench. And please jot, Hardeep Singh, Hardeep, Hardeep Singh versus State of Punjab, 2014 Supreme Court, Constitutional Bench, 5 judges. When does a trial start? Commence. A trial gets commenced after framing of charges. Okay. Before commencement of trial, every process is called as an what? Enquiry. Okay? ENQUIRY. Please read Hardeep Singh versus State of Punjab. To solve this problem, see, when does the Indian criminal procedure code came for the first time? Indian Penal Code, it is in 1860. CRPC? Evidence Act, 1872. When does CRPC came? For the first time? For the first time, not 1898. 1860 IPC, Indian Penal Code. 1872 is Indian Evidence Code, Indian Evidence Act. 1861 CRPC came into force for the first time. Got amended in 1898 rapidly. Then once again in 1973 it got amended. Then thereafter lot of amendments came. Then 2023 we had a new law which is called as Bharatiya Nagarik or Nagarik? Nagarik Suraksha Sanhita. Okay? Yes. So, for the Supreme Court to explain this one concept by a constitutional bench, it had taken nearly 160 years. Only in the year 2014, Supreme Court has. Otherwise, everybody will be telling one thing. When does a trial gets commenced? Okay? When does a trial gets terminated? When does a trial gets terminated? Judges. When does the trial commences as per the Supreme Court after framing of charges, which is held by the Supreme Court in Hardeep Singh versus State of Punjab, 2014 Constitutional Bench. 5 judges. I'm grateful, my lords. Yes. When does a trial gets terminated? See, these are all rudimentary things. Unless we understand all this, there is nothing to go inside. When does a trial gets terminated? I am an old man, 53 years old, having a hearing problem. Please be loud. The honorable judge says when the judgment is pronounced and sentence is given. Any other answer? Anybody has a CRPC book with you? Criminal Procedure Code? You take it from the cell phone? Read section 354, judgment relating to judgment. What is the section relating to judgment in CRPC? Please read 353 subsection 1. You have a mic, extra mic? Have a hand mic, give it to somebody. Some young advocates can read 353 subsection 1 of CRPC. Anybody can read loudly? What does it say? 353 subsection 1 says, chapter 27, section 353, topic is judgment. 353 subsection 1 says, the judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of the trial. It says, judgment is pronounced after the trial is terminated. Honorable judge has given an answer. When does a trial gets terminated? The judge said it is after the pronouncement of sentence. Which is right? What you find in the book is right, or what the judge said is right? What the Honorable Judge said is right. The Honorable Supreme Court has interpreted section 353 subsection 1 in Sukhpal Singh Kaira versus State of Punjab. Sukhpal Singh Kaira versus State of Punjab, 2020 Constitutional Bench. Okay. You understand, my dear? Yes. In Sukhpal Singh Kaira versus State of Punjab, 2020 Supreme Court Constitutional Bench, the Honorable Supreme Court has said a trial will not get commenced on the conclusion of the arguments of either side. A trial will not get commenced. We will come to both trial, civil trial and criminal trial. A criminal trial will get concluded on the acquittal of the accused. You all accept with me? Yes or no? Is Shillong sleeping? No? Shillong is sleeping? No. If you sleep, and then I will also sleep. You should be active, interactive. See, I am coming all the way from Madras. You are not going to answer, that is indication of what? You are not interested in the session. A criminal trial gets concluded when an accused is acquitted. Come to conviction. The Honorable Judge has given a very fantastic answer. He said, on pronouncement of sentence. That means a criminal trial has two phases. PHASC, two stage. One is conviction phase, another is sentencing phase. In the conviction phase, the judge will say, the prosecution has proved the case beyond all reasonable doubt. I am convicting you. I find you guilty. The prosecution has established the case. This is one phase. Sometimes he will not pronounce the sentence immediately. Graver the offense, he will give a time for reflection and he will say, I am posting it for sentencing tomorrow or day after tomorrow. Then he will be taken to jail without a sentence. You understand, my dear? Police people, you are understanding are you following my language? Is it difficult to follow? No. Conviction phase is a phase where the court says, yes, I believe the prosecution witnesses, their evidence, oral and documentary, the probative value is proper, so I have concluded that prosecution has proved the case beyond all reasonable doubt. After that sentence, it is called a sentencing phase. Now, for convicting a person, two circumstances are required. One is incriminating circumstances. For acquitting, extenuating circumstances. If a person has to be convicted, then incriminating circumstances should be more. What are incriminating circumstances? Incriminating circumstances are those circumstances where the crime and the criminal are connected properly through evidence. Extenuating circumstances means the witnesses in the box or the documents will show that this fellow is not connected with the crime at all. So the court will acquit. So extenuating circumstances leads to what? Acquittal. Excellent. Incriminating circumstances, conviction. Okay. Like that, in the sentencing phase, two aspects are very important. What are they? Mitigating circumstances, aggravating circumstances. The public prosecutor will argue and convince the court that there are aggravating circumstances, that the criminal is so harsh, the victim is a very thinny bony woman, the criminal is loaded with guns, she's a poor woman, or for no reason with meticulous planning he has killed. Aggravating circumstances will override the mind of the court, and the court will now say, no, I will give the harshest punishment which is available under law. Mitigating circumstances will, or you just remember like that, MI, no, mitigating MI, minimizing circumstances. That is, the court will appreciate those circumstances that this is the first time offender, he is only 19 years old, he has not made any planning for this, and this offense is not against woman and child, it is not against any this thing. For example, I am a public prosecutor for NIA. I am fighting terrorist case before the court. In this case, if the accused counsel, he argues the case on minimizing circumstances, I will use only one word. I will say that these are all offenses against individual or nation. Nation. This one word is enough for the court coming to a conclusion, yes, nation sovereignty is important over and above individual's liberty. Because only if there is a strong nation, secured nation, then only we all will be living. See, I am coming all the way from Madras, happily, no security around me, but I can reach this place. If nation is full of terrorists, then imagine nobody is safe then. All right? Yes. So a criminal trial gets terminated only on the pronouncement of sentence. The court says until sentencing is over, the judges keep on applying his mind to deliver an order. You understand, my dear? Trial does not get terminated as is seen in 353 subsection 1, that after the case is over, court will pronounce judgment. It was interpreted that unless and until a judge applies his mind in a case, trial is not over. Now come to civil side. Like conviction and sentence, civil side contains two things. What are they? A civil case should come to an end on pronouncement of a civil trial will come to an end on pronouncement of what? Judgment and decree. Nice. Now, when does a civil trial come to an end? Whether on pronouncement of judgment or pronouncement of decree? Decree. Because I told you a criminal case comes to a conclusion on pronouncement of sentence, you are repeating the same. Supreme Court said, a civil trial gets concluded on the pronouncement of judgment and not decree. Why? Any reason? Who is practicing on the civil side? Who is practicing on the civil side? Any advocate? There is no advocate here. No advocate. Amma? Oh, but there will be judgment and decree, no, for every judgment? Spirit of CPC is there. So here also I will have a judgment and decree, no? No, Judge, I am asking whether your judgment also will have a caption of judgment and decree. Only EP. See, during execution petition, They will file a petition only to execute the decree, not the judgment, isn't it? Same thing here. Okay, my question is, if you apply for a copy application of judgment and decree, the clerk there will tell you always, judgment is ready but decree is not ready. Am I right? Yes. Who is making decree? Clerk. Where from he is taking a decree? This is the knowledge and the wisdom of the Supreme Court in telling, decree is not a brainchild of a judge. Decree is the executable portion which is part and parcel of the judgment. So for decree like sentence, a judge is not applying his mind. You understand, my dear? So termination of trial in a criminal... Yes, Judge. Yes. It is just taken out of that. Right? It is a speaking portion of the judgment, or the executable portion of the judgment, or the operatable portion of the judgment. That portion is removed and put in a paper under the caption decree or decretal order for the purposes of executing the same or realizing the same by a judgment decree holder as against a judgment debtor. You understand, my dear? So we will understand these concepts. First is, a trial gets terminated in a criminal court on the pronouncement of acquittal. However, if it comes to conviction, then on the pronouncement of sentence, not on the pronouncement of conviction. If it is in a civil case, a trial gets terminated on the pronouncement of judgment and not a decree. This was the judgment of the Honorable Supreme Court in Sukhpal Singh Kaira, Khaira versus State of Punjab, 2020 Constitutional Bench. Now coming back to 530, because see why I am explaining all this is, I was taught by my senior Mrs. Vrinta Mohan that if you read one section, you should know the meaning of every word in that section, even the punctuation. Now the word in section 530 is trial and other proceedings. That is the reason I asked you a question, what is a trial? You understand, my dear? Yes. Any lawyer who wants to become a judicial officer or wants to become a good lawyer, if you read a provision, you should know the meaning of every word in that provision, every punctuation, right? Somewhere there is a comma, somewhere there is a full stop, somewhere there is a colon, somewhere there is a semicolon. Afternoon, you should tell me, because I will not leave you for the whole day, right? I am not leaving you, right? As a husband will not leave the wife for 30 years, 40 years. No, Chandru is here from morning till evening to take your lives off. Right? Yes. You should tell me in the post-lunch session, what is the difference between a comma, a colon and a semicolon? Every law you just see, there will be a comma, there is a colon, there is a semicolon. I am asking you the contextual meaning in law. Supreme Court has interpreted all that, and a comma will make all the difference. You understand, dear? So, my prayer to all the junior bar members, not for seniors and judges, is that read any provision, you should understand the punctuation, what is the meaning of A used in that, the difference between A and the, what is may, and what is, each word you should understand. Okay. Coming to 530, it says trial and other proceedings to be held in electronic mode. Now, the trial, inquiry, now the second question is, what is the difference between inquiry, INQUIR, and enquiry? Are they the same? No? Post-lunch session, I will give chocolate. Right from Madras, I have got chocolate for eating. What is the difference between inquiry, INQUIRY? In section 174 CRPC, you will find a word enquiry, either by the judicial magistrate or by police people will be knowing. Enquiry is in which section? Section 173 or 4? If a woman dies, dowry death, what is the inquiry you are conducting? Under which provision of law? Section? (174), no? They don't use provisions. They don't use provisions. Any DSP is here? Deputy Commissioner rank persons? Any senior police officers? Oh, all juniors then? Okay. Okay, all trials, inquiries and proceedings under this Sanhita, including issuance, service and execution of summons and warrant, examination of complainant and witnesses, recording of evidence in inquiries and trial, and in all appellate proceedings or other proceedings may be held in electronic mode. Now the Supreme Court has said every proceedings under the Act, every proceeding, from inquiry till trial and appeal, that is the whole judicial proceedings under this Sanhita may be held in electronic mode by use of electronic communication or by use of audio video means. Now the word is may, used is may, right? But Supreme Court a month back has given a circular to all the high courts that use hybrid mode. Don't insist on advocate to be present in the court. Okay? But we all want to go to the court and show our face physically to the judge. That too, if you want any interim orders, we will be present. Interim orders and bail, no? For getting ex parte interim injunction or anticipatory bail or something like that, we will go to the court and show our face. Right? Now the Parliament says, may be held in electronic mode. So you should understand whether this is mandatory or discretionary. What is the meaning of the word may? Discretionary. May should not be read as may. May should be read as may or shall. No, Parliament has used the word may be held in electronic mode. This has to be read as shall or may. Okay, I will ask another question. If may is there in a provision, should it always be read as may or sometimes you can read it as shall? When? If shall is there, it has to be read as shall or you can read it as may. Once again, I think all the chocolates will go to the Honorable District Judge. Judge, post-lunch session, you bring a big bag. Okay? But for you, nobody is opening the mouth. I do not know why. See, I am not your teacher. I am your friend. I am not going to put any marks. Especially 0 will not be given to anybody. So open the mouth. Right? Yes. Shall. Normally, one trick you should learn from the wisdom of honorable judges, even if the word shall is there, okay, these are all rudimentary principles with which you should be very, very careful in understanding. Every shall is not shall. Unless following that shall or following the provision, there is a consequence for non-following the provision. In law, the word shall will be used. That is simpliciter. On the face of it, it means mandatory. Whenever the word shall is used, it is an implication to the judge that it is mandatory. One thing. If that shall does not have a consequence, that means if that provision is not taken as a binding thing, then is there any punishment prescribed or is there any consequence for that? If no consequence, then Supreme Court says that shall be read as may. For example, previously section 154(1) of CRPC. What is 154(1) of CRPC? 154(1) of CRPC. Registration of FIR. In Lalita Kumari versus Government of UP 2013 Constitutional Bench. You all know about Lalita Kumari? Lalita Kumari versus Government of UP 2001. Supreme Court says the word shall used in 154 subsection 1. That is 154 subsection 1 is every information revealing a cognizable offence given orally before a police station shall be registered as an FIR. For this one word every and shall, 5 judges said all the information has to be received, only test is whether it reveals a cognizable offence. It shall be registered means police shall register it, otherwise section 166 IPC says if a law is not followed, the person who is not following the law should be punished. Right, sir? For the consequence under 154 shall, Supreme Court goes to IPC, section 166. 166 says if anybody don't follow, if a person doesn't follow the law, he will be punished. So Supreme Court in Lalita Kumari said the word used in section 154 subsection 1 shall is mandatory. A policeman shall register FIR if it reveals a cognizable offence. Okay? Nice. Good. In the same section, you go to section 154 subsection 2 CRPC, it will say like this, copy shall be given to the informant. What about this shall? Shall or may? Give him some water. Give him some water. He's sneezing. He's coughing. Brother, you give him some water. He is coughing. A copy 154 subsection 2. A copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant. Whether this shall is shall or may. There can be only 2 answers. One is shall, another is may. A person from my state, from Tamil Nadu, went to the Supreme Court stating that copies as mandated under 154 subsection 2 was not given to me, so strike off all the proceedings. Supreme Court said 154 subsection 1 is mandatory. 154 subsection 2, even though the word shall is used, it should be read as may. Because the consequences of not registering an FIR is more disastrous than the consequences of not giving a copy to the person. You understand? It is in the case of state represented by Inspector of Police Chennai versus state represented by Inspector of Police Chennai versus N. S. Jnaneswaran GNA NESWARAN state represented by Inspector of Police versus N.S. Jnaneswaran GNANESWARAN Jnaneswaran 2013 Supreme Court. Supreme Court says the word shall has to be read as may. Similarly, in CBI versus Master Bolu, CBI versus Master Bolu, BHOLU, 2020 Supreme Court, in Juvenile Justice Act, preliminary assessment. What is the provision for preliminary assessment? Section 14 or 15? 15. In that, the word used is a child during preliminary assessment may be subjected to a psychological test. Supreme Court has held that in CBI versus Master Bolu, BHOLU, in that the Honorable Supreme Court has interpreted the provisions in section 15 of the Juvenile Justice Act may. as shall. The Supreme Court said the word may has to be read as shall. So whenever, as the judge has rightly said, the word may become shall. The word shall may become may. Okay. Now 530, having read 530, what are the other important aspects of the new law? As you all know that previously we were having in the criminal justice system, we are having a judicial magistrate, then metropolitan magistrate. Above the judicial magistrate was judicial magistrate, chief judicial magistrate. Here do you had a court like metropolitan magistrate? No. Thank God. So now it has become 3-tier. That is a judicial magistrate court, over and above a chief judicial magistrate court, there is no assistant session judge. Previously there was another one cadre called as assistant session judge, that was removed. So judicial magistrate, chief judicial magistrate, session judge, high court, Supreme Court. Okay. Now it has become a 5-tier in the new criminal law. Okay. Yes. Now, any public prosecutor is here? APP, special PP, only one? Only one. Any PPs are here? Special PP, APP? 1, 2, only 2 persons are present. Okay. Now, previously it was section 24 of CRPC. What is the new provision governing public prosecutors in BNSS? Section 18. Okay. Okay. I will tell you some important judgments for the public prosecutor and for the defense also. Suppose a defense lawyer conducting a criminal case, or the victim finds that the public prosecutor is not up to the mark, or purposely she or he is not prosecuting the case properly. What is the remedy? Remedy in old CRPC is 24 subsection 8 proviso. What does it say? A victim can engage a lawyer of his or her own choice. That is over and above the public prosecutor. 24 subsection 8 proviso, which was an amendment of CRPC, says a victim can also, with the permission of the court, can engage a lawyer of his or her own choice. Because many a times the public prosecutor or additional public prosecutor or APP, if at all it is a political appointment, rarely they will also abide by their political masters. They may not do justice for the victim. In that case, 24 subsection 8 proviso says you can apply for an intervener application and you can defend your case, you can prosecute it, this thing, right? Normally courts will not allow the intervener application or the intervening advocate also. They will say you file arguments at the time of conclusion of trial. Supreme Court, now the provision is 18 subsection 8 proviso of BNSS. 18 subsection 8 proviso. Right? Victim can engage advocate of his or her own choice. You can file a intervener petition anytime in a criminal case, intervening petition. Right? You please read the judgment of Rekha Murarka, R-E-K-H-A, Rekha Murarka, M-U-R-A-R-K-A, versus State of West Bengal. Rekha Murarka versus State of West Bengal. It is a judgment of 2011-2019 Supreme Court. Rekha Murarka versus State of West Bengal, the Honorable Supreme Court has said the scope of a person defending a victim, right, is more expanded than the ancient thought of telling that he should only come at the time of conclusion of trial and supplying for arguments and all. Supreme Court has said right from the inception of the case, that is from the beginning of bail itself, a victim can be defended, and if the prosecutor is not asking proper questions, then the person who is defending the victim can also give proper questions which are required to the judge And if the judge feels that it is essential and required for the case, then the judge will ask all those questions to be put to the witnesses, prosecution witness. Please read Reka Murarka for effective prosecution of a case. Apart from that, can a prosecutor have a choice of picking and choosing witnesses from the list? Yes or no? Yes. Supreme Court says in Dalbir Kaur versus State of Punjab, Dalbir, D-A-L-B-A-R, Dalbir Kaur versus State of Punjab, Supreme Court says he can pick and choose, but it should be fair and it should not be destructive of the prosecution case. Dalbir Kaur versus State of Punjab, 1976. Honorable Supreme Court says a prosecutor can pick and choose witnesses from the list of witnesses, but it should be fair for a fair trial and not destructive of the prosecution case. That is, he cannot sail with the accused, destructing his or her own case. Okay? Then, this judgment is for both prosecution and defense. There is one thing called as chief examination, followed by a cross-examination, thereafter re-examination. What is the provision in erstwhile Indian Evidence Act? Oh, you don't follow the act, no? Evidence Act you follow. What is the provision for re-examination? How many of you here advocates have at least once asked for a re-examination? Or how many PPs present had at least once said, I have a re-examination? Nobody? From Monday, you troubled the court by re-examination. After reading Rami, R-A-M-M-I, Rami alias Rameshwar, R-A-M-M-I alias Rameshwar versus State of MP, 21/9/1999, Supreme Court. Rami alias Rameshwar versus State of MP, 21/9/1999, Supreme Court. It says, the scope of re-examination is not confined only to ambiguities, because whenever you try your luck in a court of law before a judge, you just say, if you are for an advocate who has taken chief, who will take a chief? If you examine the plaintiff counsel will take the chief. If you examine the defendant counsel will take the chief. After the cross is over, if you tell the judge, I have a re-examination, the judge will immediately ask you a question. What is the question? What is the ambiguity? Then you will sit, no ambiguity, you will sit like that. Especially public prosecutors. Supreme Court says, the concept of re-examination is not confined only to ambiguities. So, even if you have not culled out anything from chief, please read Rami alias Rameshwar. The scope of re-examination is more wider than what we are thinking. Okay? Yes. Next question. Whether a public prosecutor can tutor a witness. You will always find in court, no? A policeman with bundle will tutor the witness in a hidden place. Right? Can a public prosecutor call the witnesses, list of witness, before he enters into the box and at least talk with him, interview with him? Under the name of interviewing, will tutor, that is different thing. Whether refreshing memory should take place in the chamber or in the court, you should say the answer. Hukum Singh, H-U-K-U-M, Hukum Singh versus State of Punjab, 14/9/2000, Hukum Singh versus State of Punjab, 14/9/2000, Honorable Supreme Court says, a public prosecutor has every right to call the witnesses, to summon the witnesses ahead of the case and have a talk with them. To the extent of he can ask him, what is the case? What do you know about the case? What are you going to depose? See, the role is, if you appear for the plaintiff, as you call the plaintiff and talk in your chamber, in your residence, the list of witnesses are the public prosecutor's witness. He can have any amount of interaction. Please read Hukum Singh versus State of Punjab. Okay? 14/9/2000 Supreme Court. Then, coming to a controversial topic of arrest. Okay? Who can arrest whom? Who can arrest whom? Anybody can arrest anybody? Or everybody? Whether a civilian like me can arrest anybody? Yes. When? When in front of me a cognizable offense is getting committed. Only purpose is to prevent him from further damaging. Okay, this is one thing. Otherwise, the power of arrest, is it with the magistrate? As a person, as a civilian, magistrate also has a power of arrest if a cognizable offense takes place in front of him. Okay. Apart from that, can the Honorable High Court or Supreme Court direct the investigating agency, go and arrest Chandru, go and arrest this accused? Can any court in the country, including the Supreme Court, order for arrest of a person when investigation is under process? Unless you say yes or no. From the magistrate, from the magistrate till the Supreme Court, can any court in this country decide that this fellow should be arrested when the investigation is in process? This is one question. Second question is, can any court in this country, from the magistrate till the Supreme Court, say, file a charge sheet like this? Can a court order the policeman to file a charge sheet? Yes. You can always say, you investigate and file a charge sheet. That means it can be a negative charge sheet, that is, they can drop it on mistake of fact, or they can file a charge sheet. This is one thing. Every court in this country has a supervisory power over and above the investigating officers for directing them to do a proper investigation. Court can say, you do a fair investigation, you do a proper investigation. No court, including Supreme Court, should say, you should file a charge sheet implicating him like this. See, a court cannot expect an investigating agency to do a certain thing in a certain way, or you cannot say that you file a charge sheet in the manner which we want. Okay, this is one thing. Second question is, no court in the country, including the Supreme Court, can order for arrest of a person, because arrest is there are a lot of Supreme Court judgments. Supreme Court has held at the High Court lot of times. Why is that you have ordered arrest? Because arrest is the prerogative of whom? Investigating officer. Whether to investigate somebody, whether to arrest somebody, not to arrest somebody is purely in the realms of the police, and for that they should write reasons. Okay? Any person who holds an office in this country, should write reasons. Because every person holding an office is holding it under the rule of law. Nobody is a king in this country. From the president till a poor man like Chandru, nobody is a king in this country. Everybody is governed by rule of law. So Supreme Court also cannot order for arrest of a man in a case when investigation is pending. But judge has said one thing, he has distinguished. He said you can always issue a warrant of arrest. What for? He would have given a promise by way of bail. He would have given an accused in a criminal case, got him binded himself before a court, either personally or through bond. He would have given a promise that I will appear before the court of law. This is one occasion where a court will issue a warrant of arrest, stating that he has violated his promise, I am issuing warrant. Second is, in a case where an accused is absconding, in the sense, right from the registration of FIR, nobody would have seen him ever. But court would have filed a charge sheet called as absconding charge sheet. In that, court will initiate a process called as proclamation process. Then the court will say, I am proclaiming that this fellow has committed the offense. Court will conclude now in new criminal law, provisions were added that we proclaim him like in a civil case. Right, in a civil case, if a defendant doesn't appear, what we will do? Call him absent? Set ex parte. There is ex parte in Meghalaya, no? Yes, but nobody is opening the mouth. Call him absent means then what should follow? Called absent? No, there is no ex parte here. Whether the judge will not write this thing, defendant called absent, set ex parte for plaintiff evidence. Is there anything like this? Yes, but you should all open the mouth. Either you are not understanding what I am talking or the procedure is different here. No. You are all scared of honorable justice. My lords, I think they are all scared, my lords. Every superior court judge, according to me, he is like our father and mother. I am from the heart, I am telling. Every person in the hierarchy, greater the hierarchy, every person, all judges hold the concept of parens patriae. You know that? Every judge in a court sits in a chair of parens patriae. What is it, parens patriae? What is the root word? Parents, P-A-R-E-N-S. Parent. Any judge in a court of law is a parent for both the parties. That means he is sitting in the center. He is not only sitting in the center, he also holds the case in the center. The victim is like one daughter, accused is like another daughter. Whatever is just, a judge is expected to do. Judges are sitting in the concept of parens patriae, like the legislatures. Right? They are judges only in the court. Otherwise, they are parents for us. We can take every guidance from them. Right? Yes. Now, coming back, the prerogative of arrest is with the police. They should pass reasonable orders. What are reasonable orders? Tell me. What is a reasonable order? I will tell an example, you understand. If magistrate passes an order, CJM is satisfied on that order, it is a reasonable order. Is it so? Is it so? Okay, magistrate passes an order. CJM is accepted with that order, satisfied. Is it a reasonable order for CJM? Yes. This order of magistrate and CJM both goes to High Court. High Court accepted the order of CJM and magistrate. Is it a reasonable order in the minds of the High Court? Yes. Supreme Court fires all the three. Order is perverse. Now, is it a reasonable order? No. A reasonable order is one which suits the frame of law under which the order is passed. Yes, my dear? Please understand, a reasonable order is not pleasing a superior or not passing an order expecting that my order will go to this person now. So, not drafting the order suiting a superior is a reasonable order. Any reasonable order should suit the rule of law. Okay? What is a reasonable order for an advocate? An advocate who has applied for bail before a court of law. Dismissal or grant? Grant. What is a reasonable order for a PP like me, public prosecutor? Dismissal. So reasonability should not pass the test of person standing in front of us or who is sitting above us. Reasonability should pass the test of BNSS and Constitution. Okay, yes. Now we will come to, we have discussed something about arrest. Okay. Cognizable offense, non-cognizable offense. Cognizable offenses are those offenses for which policeman can arrest without a warrant. You understand, my dear? Yes. Now, Supreme Court has come down heavily for malicious arrest and irresponsible arrest. Yes. What is a malicious arrest? What is an irresponsible arrest? malicious arrest is in political cases. If one man comes into power, the police is always with the ruling party, isn't it? Yes. See, you are all advocates. You are not opening mouth. I thought you are all very brave and vociferous. But there is some problem. You are not opening the mouth. I have told you that Chandru alone is getting recorded. I am guaranteeing you, you will not be shown faces in that. Okay? Yes. Malicious arrest is with some malice. If a policeman arrests without the case, proper case, if a policeman arrests another person with malice, with ill will or motive, then it is a malicious arrest. Okay? Now the question is, see, I have come down from Madras. Today evening I am going for a walk. Right? In the meantime, I have stolen the chain of Didi is wearing a chain which is very attractive. There is $1 also in that. During lunchtime, I will make a chain snatch. Right? Evening, I am going for a walk. Didi has found out that Chandru has stolen the chain. She has given a complaint of chain snatching as against me. During the evening walk, one police person, inspector of police of this jurisdiction, he wants to arrest me. How can he effect arrest? He will come and explain, Chandru sir, you have stolen the chain of Didi in academy. Please come, I am going to arrest. Whether any police person will say like that, sir, brothers? You say like that? No. What you will say? The moment you go in your jeep and put the jeep in front of a man, he will start pissing in the pant. Then you will catch him and put him in the vehicle. Is it? No. If you want to arrest a person, will you explain him the grounds of arrest? Explain. True. You are speaking truth in a campus of High Court. I am talking truth. I want everybody to speak the truth. This is academy. You should interact. Right? Now the Supreme Court has understood that no policeman in this country is explaining the grounds of arrest. That means arrests have become violent and norm. Previously, Supreme Court in Joginder Kumar was a state of UP, 1994, Joginder, J-O-G-I-N, Joginder Kumar was a state of UP, 1994, followed by Arnesh Kumar versus state of Bihar, 2014. Joginder Kumar was a state of UP, 1994, followed by Arnesh Kumar was a state of Bihar, 2014, then followed by Satyender Kumar Antil, S-A-T-E-N-D-E-R, Satyender Kumar Antil versus CBI, 2021, 22, 23, 24, 25, 26, 5 judgments are there, 5 years. Satyender Kumar Antil from versus CBI, 5 judgments are there. Kindly go through all the judgments. All the judgments are related with arrest and bail. Okay? When arrest can be made, how bail has to be granted, when bail should be granted. If you are a defense advocate, follow all this. All these are very in all these, Supreme Court has given guidelines as to arrest with a 41A notice, which is corresponding to 35 subsection 7. Please jot down, my dear. Any police person who has to arrest a person should definitely furnish a 41A notice that is corresponding to 35 subsection 7. a notice should be, especially if the offense is punishable for less than a period of 7 years. If an offense is punishable less than a period of 7 years, then the police person is mandated under 41A and 35.7 of BNSS, 41A of CRPC and 35.7 of BNSS, and all the judgments starting from Jogi. For the first time, I am hearing some provision from you. Order 7, Rule 11. In a rejection of plaint, court should look into only what averments? Who is telling that? Oh, no one else. In a rejection of plaint, court should look into the averments of the plaint and the documents appended with the plaint. Right? The defendant who is filing the rejection of plaint should not file any documents. Court should not look into the materials of the defendant. Like that, in a discharge, court chance of hearing the government servant who is an accused, and you also have a chance of looking into the report of the superior officer also. Now the Supreme Court has given an interpretation in the lines of Priyanka Srivatsav and in the lines of Ramdev. Section 175 subsection 4 is interpreted. You take this judgment, magistrate should ascertain the truth of the complaint before summoning the accused. This is in the case of Rekha, R-E-K-H-A, Rekha Sharad, S-H-A-R-A-D, Rekha Sharad Ushir, U-S-H-I-R, Rekha Sharad Ushir versus Saptashrungi Mahila Nagari Saptashrungi, S-A-P-T-A-S-H-R-U-N-G-I, Saptashrungi Mahila, M-A-H-A-L-A, Nagari, N-A-G-A-R-I, Shakkari Pat Sanstha Limited, Mahila Nagari, S-A-H-K-A-R-I, Sakkari Pat Sanstha, P-A-T-S-A-N-S-T-A Limited, 26/3/2025. The object of recording the complainant statement under 223 of CRPC is to ascertain the truth. Learned magistrate is duty bound to put questions to the complainant. Under 156(3) application, nothing. Now the court says under 200 CRPC, the magistrate is expected to put question to the complainant to elicit truth. All this is devised by the Supreme Court, because if you approach the police fails to raise an FIR, court is having a doubt in its mind. This man is using the private complaint procedure for the purposes of harassing somebody where police have rightly rejected an FIR. You understand, my dear? So this is the protection now. Okay. Shall we stop it? Which time we can resume? 2:30? 2:45? Yes. Afternoon I will tell you some more judgments on new criminal law, and we will go to an interesting judgment which is State of UP versus Ajmal Beg. Very interesting case. A girl was killed, as sir has felt. A girl was beaten, burnt. She was burnt alive to the extent that the whole house was also burnt. And the people who burnt her was seen running. See, husband, father, that is father-in-law, mother-in-law, were seen by husband's relative that they were running out of the home. Usually what he will do, if a girl is inside, whether he will run out of the house, we will take some effort to take the girl out. What we will do as a human being? Some effort. Here is a case in Ajmal Beg. She was burnt totally baked like our tikka, including the whole house. Now Supreme Court has given various guidelines in this case for honorable judges, for police people and for PP as to how a case under 304B has to be, that is dowry death has to be dealt. Okay, remaining we'll see in the afternoon. Thank you so much. You are all very patient, right? Your patience knows limit. Speaking nonsense can be done for hours together, but listening to a nonsense is very difficult. Okay, thank you so much. Love you all. Okay, good afternoon, everybody. An interesting question came before the Supreme Court, where the question was whether an event has taken place. That is, a crime has taken place, a complaint was lodged in the way of a private complaint, and court has rejected it, not to take because it has not, no offense is made out, right? The very same complaint, the very same event was rephrased in a better way. Very same event was rephrased in a better way, like adding some spices to that as if some other offenses has taken place, right? A legally drafted complaint for the same incident on which the court has taken cognizance and dropped, a second complaint is not entertainable, right? You understand that? Yes. It is very useful for the advocates. Rani Mol, R-A-N-I-M-O-L, Rani Mol and others, a latest judgment, versus State of Kerala. Mol is daughter. Mol means daughter, M-O-L. Mol means daughter. You call somebody very passionately as Mol. You like somebody, no? Then they will call in Kerala. Anybody from Kerala? Any Malayali here? Okay. It is my neighboring state, no? So my senior Mrs. Vrinda Mohan is a Malayali lady. So I can understand Malayalam and learn and talk some Malayalam also. So Rani Mol and others versus the state of Kerala and another 18th November 2025, the Honorable Supreme Court has laid down that second complaint for same offense, abuse of process of law. That too, if there is a negative report, closure report after a detailed investigation, okay, it is an abuse of process of law. So you can use this judgment then. Here, do you have that Domestic Violence Act? You have that? Okay. Is there any framing of charges in that? Why, Judge? Why no framing of charge? Why? The Honorable Judge is telling that the Domestic Violence Act is a civil law. Do you accept that? Who conducts it? Magistrate. If a magistrate conducts in a criminal court, can a magistrate conduct a civil case in a criminal court? Yes or no? No. She says no. Have you heard about 125 CRPC, 125 CRPC? In which court? Magistrate court or family court? Just because a 125 CRPC is conducted before a criminal forum, then the relief will not become a criminal relief. 125 CRPC settled law proposition is, it is a civil law relief before a magistrate court. As the Honorable Judge rightly said, you can read the judgment of Indira Sarma, I-N-D-I-R-A, Indira Sarma, S-A-R-M-A, versus V.K.V. Sarma, V.K.V. Indira Sarma versus V.K.V. Sarma, 2014 Supreme Court. The Honorable Supreme Court has held that domestic violence, the scope and objective of that is that the Parliament has felt that civil law remedy is not adequately addressed to the victim in a domestic setup. Okay? What is this domestic setup, first of all? Whether this system now it is a domestic one or non-domestic? Domestic. Elephant is domestic or wild? Elephant. Wild. Dog. Cat. In law of torts, we would have read something like ferre naturae and mensute naturae. Mensute, root word is men. Mensute naturae, by nature, it gets adapted with men. Ferre, ferocious by nature. So in animal kingdom, it is classified, animals are classified conveniently, comfortably as ferre naturae and mensute naturae. Okay, from morning you are looking at me. You may think that I am a very good person, religious person, good man, right? Had I got married with one stupid, you should listen to her, how she is explaining about Chandru. See, we all want to act as gentlemen in outside the home, right? Inside the home, absence of anybody, what do you think makes you a gentleman? If you are alone, not governed by anybody, what is the reality determines who you are, right? The law which we are discussing now is protection of women from domestic violence, right? When I ask a question, how do you classify dog? Answer came very nicely, it is domestic. Elephant, wild. Tiger, wild. Ask the spouse of you. Ask your son. Ask your daughter-in-law. Ask the mother-in-law. How do she or he will define you? Domestic or wild? How do you define yourself, first of all? I define myself as neither domestic nor wild, neither good nor bad. I have seen godly people. Okay? More godly than God at all, if at all there is a God. I have seen people who had committed crime because the circumstances had made them like that. We are all remaining good people, pretending as if we are good because of the nice environment. My father was a dentist, a middle class family. My mother is a good lady. I have never seen my father and mother fighting. They got married in the year 67. My father passed away 5 years back. I have never seen both of them fighting. I was born in such an environment that there is no violence around me. So Chandru can happily stand here and talk all great things because not faced any violence, not faced any crime, not in poverty, not even for one day. Think of people who are standing in front of you. Honorable Judge, during the lunchtime, he has told me, it is the background and culture through which a witness deposes in the court, through which he behaves in the court also. See, please think that a man standing in front of you for justice is of a different species, culture, environment, and you cannot scale him by your ethics, by your value. Okay? You should be a good man first. Last week, fortunately, I was in Maharashtra Judicial Academy. Around 60 trainee magistrates, around 20 district judges, trainee judges, DJs. One good man, honorable judge by name Rajesh Patil came. Right. I had taken classes for him on PMLA when presently he is a High Court judge. 2 years back, he came for a session. Myself and Justice Sanjeev Kalgonkar of Madhya Pradesh were handling a PMLA class, right, for him. He was the one who has to introduce me and he has to deliver lecture on some law. I was taking session on domestic violence and the niceties or nuances of bail and anticipatory bail for all these judges from the morning till 4 o'clock, right? This honorable High Court judge, believe me, he was addressing them for half an hour as to how you should behave as a good human being. He has not taught any law. I cherished that man. He's a good man. He's a good human being. He was just addressing the judges. He told them, be a good man first of all. If you are a good man, you will be a good father, you will be a good son, you will be a good son-in-law, you will be a good judge also. A good judge, law-knowing judge, may not be a good man also. He may be a good judge. He may be a legal luminary, a jurist. If you ask my mother, she will say, my son is the holiest man on the earth. You should ask my junior. She will say, this man is a terror. You should ask my neighbor. See, how do you conduct in the society matters much. Okay? So why do you ask a question about the domestic and all this is always feel that we should not be wild. This is a small journey, my dear. Nobody knows about the next moment, not even tomorrow. Right? Contribute for your own self and for the country. Country is very important. And your family is also very, very important. You should love your wife. I told an example of my own father and mother. Please don't harass the woman with you. All right. Who is a good man? Who has never scolded the wife, never beaten the wife. Of course, you can have some beatings or scolding from her. It will not be painful, no? See, women are basically like rose flowers. Very sweet, very smart. They're very sweet. Even if your wife gives a small slap, then you can hug her and give a kiss in return. Then there will be no quarrel. See, imagine, why my request for all this is, imagine a life of two parents litigating in the court. How can you produce a good children? You can be a judge, you can be a superintendent of police, you can be a king also. If you are fighting with your wife in the family, then it is finished. Okay. Think of the children behind you. They should think you are their hero. See, anywhere I go, I will start with this, with the blessings of my parents and my teacher who taught me law. But for these three people, just imagine, I would have been roaming somewhere in the streets, or would have become a minister also. Right? A person who doesn't follow anything, either I should have been in jail, or I know the trick of cheating and making money, and I would have stood in election, give some money, and once again I would have become a minister or anything. Produce good children, it is in your hands. Please make a vow from today not to fight with your wife and husband also. And don't think they are your property. Nobody is your property. One day God will come, Yama will come, take off this flesh and soul, it will go to the graveyard, you will not even be permitted to see that. You will be thrown off. Please don't fight with anybody, especially with your family, unless you have a happy family. Imagine I have lot of problem around. One judge from my court, high court, is a very good human being, nice man. I was taking classes in NJA. He was also taking classes for another session. Evening he met me and said, Chandru, do you remember around 5,000 judgments? I said, my lords, I am not married, no, so I am having this. It was a joke. Imagine a man with a lot of problems in his head. He cannot do anything, not even the assignment which was given to him. So, live a life without any problem, right? Be a good man. Nobody has seen God. I do not know whether God is there at all. I believe in God, but I do not know whether He is existing. In the name of God, don't fight. In the name of God, don't think you are very holy also. And don't harass people with you, near you. And if you are a superior, don't harass the inferiors. If honorable district judges and CJMs should be like good mother-in-law and good parents. And Judge, what is your name? Sangma Judge, while eating, he told, today my mother-in-law has prepared the food, it was very nice. Right? See, the smile of this man and the energy of this man implicates that he is living a good family, happy life. Imagine the mother-in-law is inimical with him. Wife is inimical with him. With all happiness, he was taking that inside as if he is a new son-in-law in the family. He is maintaining that love life. I was listening to him, he was telling to the other judge that it is my mother-in-law, she makes good rotis. Create such a culture around you, and this is the real wealth. All this ill-gotten money, see, some people, like ministers, police, judges, advocates, all this corrupt money, what will happen? One day a doctor like us will say, I have to operate 50 lakhs, 1 crore, finished. Within 1 second, wink of the eye, a super specialty doctor, he is a greater thief than us. Right? He will just take out of your packet and you will be lying semi-conscious, he will take the money. Don't believe in any ill-gotten money, brother. Right? We all died. When my father died as a good man, I was very happy. After his death, there are a lot of jewels. And I thought, on a philosophical side, I thought, what is the use of all this gold? My father has given a good knowledge, given me a good spirit, good intention of being a good man. I will tell a small example of my father and we will go to the session. He was a dentist, I told. I became an advocate, started conducting criminal cases, right? I used to go to my house residence 1:30 or 2 o'clock in the night. My office starts by 7 o'clock every day. 6:45 I will go to the office. I was with my senior for more than 15 years. Not even one day I was impunctual. Not even one day. 7 o'clock is the office, I will go by 6:45. And she retires by 11 o'clock. Myself, other juniors will go to home by 2 in the night. Right? One day I went to my house by 2 o'clock. By 2:30 I started to sleep and there was knocking in the door of my house. Because I am conducting criminal cases, I imagine myself as Ram Jethmalani, right? Thinking that somebody has come to the house with a gun or to beat me, some imagination. And one man was knocking. And he was also putting some cloth and all and holding like that. I was imagining that somebody is in disguise coming to the house and knocking. And he was knocking repeatedly. I was asking, who are you, who are you? He is not responding. A tall, stout man. I am not opening. My father immediately came. He will sleep only in the hall, on the floor in the hall. No room, no AC, nothing. Right? Came. He just asked me one thing. He will call me a Suja, girl's name. Right? Because if I unfold it, now also I have a long hair. So my father will love me by calling by girl's name, Sujama. Right? He asked me, Suja, why is that you are scared? Who will come to this house? Without asking anything, he opened and he told me, somebody with pain will come here. Who else will come? You understand? If somebody comes and taps, my father, that man was of the belief that nobody will harm him. No untoward things will happen to him. Because of the life he is leading, he's a honest man, he's a dentist, some patients will come for help. Opened it, this man was putting this around and he was touching my father's leg and said, Doctor, pain is too much. He woke up my sister, gave a dolo or something to him, asked him to sit for some 10-15 minutes. After that he has told me, see, you should not get scared for anything. If you live a honest life, truthful life, who else will come and tap? And you cannot resist death also. That also he said. He said if somebody wants to finish you off, he will finish you off. Don't live a life where you get scared always. This is the enlightenment that I got from my father that day. He just came like a military person, opened it, he said, come inside. As a lawyer, a son of my father, I don't have that courage. Because something is telling that I am conducting this case, that case, somebody will fire. My father added that if somebody fires you also, you cannot prevent. When Indira Gandhi can be killed, Rajiv Gandhi can be killed with a lot of police around. Just imagine, I am a special public prosecutor entitled for a gunman. Remembering all this, when they asked me, sir, you want a protection? I said, no protection is required. See, we are not in Jammu Kashmir, right? Even in Jammu Kashmir, nobody has killed a judge. Even in a place like Jammu Kashmir, who has killed a judge? Whether the terrorists are going to the court every day and firing, they also, see, you name them as terrorists. There is some ideological difference between them and the government. They take the gun and fire, but they have not killed public prosecutors, they have not killed any judge. This is a peaceful country. I am telling you, be optimistic, this is a peaceful country. I asked a question in Tamil Nadu State Judicial Academy to my judges and police people like this. What is the population of Tamil Nadu? The population of Tamil Nadu is 8 crores. Right? Any junior advocate, you tell me, how many criminals will be in Tamil Nadu jail overall? 8 crores of population. How many, what will be the population of the prison, including all prisons, sub-jail, jail? Guess and tell me. 8 crore is the population of Tamil Nadu. 8 crore. How many people will be under trial, convicts? How many? Some guesswork. 1 crore. One crore is 100 lakh ma. How many? Judge, guess. Ji? I will give you a kiss during tea break. Okay, 25,000. He is worth of a kiss really. Such a sweet man. See, if you keep yourself very honest and clean, answers will prop up. Just 25,000 out of 8 crores. Imagine you also make a survey in your place. It is 0.00001 or something like that. 800 crores, only 25,000. For this 25,000, there is a judicial academy, there is a police academy, there is a home department, home secretariat. See the drama. If one crime is committed, it has to be flashed everywhere. Then only this judiciary system, police will be there. Otherwise, if you show that this place is very peaceful, happy, good people are around there, then where is the question of defense lawyer, prosecutor, judges, judicial department, jail? Just 25,000. You make a survey across the country. People are good. See, you and I are alive till this date. No, that itself is an implication that people are good around. Nobody is taking guns and firing us every day. So please have an opinion that this country is a good country. Dehors the projection by the press. If good things are not, see, if one judge retires as a good judge, no media will report that a good man has retired. If one corrupt judge is removed, across the country that is the news of the day. It should be the other way around. Good persons has to be projected much, such that it gains confidence to the younger generation that, oh, I am living in a good place, energetic place, people are good. So change the attitude. See, why I am telling all this once again is, you are all people whom are connected to lakhs of people. Please disseminate all this. Okay? Yes. Framing of charge. I asked a question, simple question, whether in DVC framing of charge is there. Honorable Judge has said in 12 also, section 12 also, it is an application to magistrate. Morning I told you one thing. 156 subsection 3 is a 156 subsection 3 CRPC. Is it a complaint? Application. Section 12 is an application. 156 subsection 3 we told there is no sworn in there. Judge will not take a sworn statement. Here also in DVC, section 12 says application to magistrate. It is a civil law remedy. Because there is no framing of charge in DVC, there is no discharge. You understand, my dear? There is no discharge in DVC because there is no framing of charge. It is a civil proceedings. As he rightly said, if an order of a judge is not obeyed, only for disobedience of various orders, how many violence are there in DVC? Section 3. You remember like this. A man beats a woman and commits domestic violence. What she will do in the home all alone? If she receives beatings, what she will do immediately? Natural response. Weep. What is the spelling of weep? W? W-E-E-P. Right? Weeps. Take the W off and put V. V-E-E-P-S. Section 3 says verbal, emotional, economic, physical, sexual abuse. Okay? In DVC, domestic violence, weeps. 5 types of abuses. Verbal, emotional, economic, physical, sexual. Okay? Yes. So, it is not a criminal offense, but if disobedience of order is made under section 31 and 32, it becomes a criminal offense. Okay? Then, one another important aspect in BNSS is time frame. Today morning I told. Previously, defense lawyers used to play all dramas in the court. Suppose there are five accused. One will first file a framing a discharge application. There are 5 accused in a case of murder. One will file a discharge application. What the judge will do? Ask the public prosecutor to file counter in that. Then inquiry, it will go for years together. Then somehow he will go to the High Court, get a stay on that. Okay? From there, you will go to up to the Supreme Court. 10 years would have passed. Then when the matter is ripe for trial, the second will begin take the baton and begin the relay race. You know that. I think you are not doing all this here. All seems to be very good people. If there are 10 accused, all the 10 will try their luck by filing discharge, one after the other. So the court will never see the trial at all. Now the new BNSS says, a discharge application by an accused in a case has to be filed within 60 days from the date of receipt of free copies. You understand, my dear? So all those old dramas cannot be made now. Accused means all the 5 accused or 10 accused. It is not that one completing the other. Now in BNSS, Supreme Court says, section 251, okay, class B, subsection 1, class B. Section 251, subsection 1, class B would indicate that whether the matter is exclusively triable by the Sessions Court, the court should frame the charges against the accused within a period of 60 days from the date of first hearing, if it is a Sessions case. Why? In a Sessions Court, but for special in a Sessions Court, but for special courts, free copies are not given. Where free copies will be given? In a Sessions Court, right? Free copies will be given for a Sessions trial by the magistrates in preliminary register case in PRC proceedings. In special court, where a session judge is sitting as a special court, where there is no committal proceedings, then in that court, furnishing of free copies are there. So suppose, understand very clearly that in BNSS, under Bharatiya Nagarik Suraksha Sanhita, framing charges should be completed and discharge also you should file it within 60 days from the date of receipt of free copies. In Sessions Court, there is no receipt of free copies. So, it should be within 60 days from the date of first hearing. Okay. So, whatever it is, there is a time frame in which you should file a discharge application. Supreme Court now says, all these non-framing of charges and all these dramas leads to greater delay, and delay leads to non-renderance of justice to the victim. Victim has to see the fate. She has to hear that, oh, this fellow is convicted who has assaulted me. Or else see the fate of the victim. She or he will not die in peace. Okay? Please jot down this judgment. That time frame has to be taken seriously by everybody across the country. Supreme Court has given in Amman, A-M-A-N, Amman Kumar versus State of Bihar, 29th October 2025. Aman Kumar versus State of Bihar, 29th October 2025, Supreme Court Division Bench. Supreme Court says, we are of the considered opinion that certain directions requires to be issued pan-India in this regard. That is, Supreme Court says, this 60 days time and the complaints of that, we have to, because whenever something is in law, I will interpret it in some other way and the prosecutor will speak in some other way, judge will take some other opinion. If it is given as a guidelines from the Supreme Court, then everybody will say there is a judgment of the Supreme Court. Whether judgment of the Supreme Court has to be obeyed? Obeyed? Why? Honorable Judge Morning said, if there is no consequence, it should be taken as discretionary. Non-obedience of Supreme Court judgment will lead to what? Contempt of court. Straight away jail. You cannot contest the proceedings of contempt by arguing in the Supreme Court. Contempt is between the judge and the contemner. Nobody can intervene and speak anything. Especially in Supreme Court and High Court, contempt proceedings are like Hitler's proceedings. Why? A man who has disobeyed the court's order, where is the question of fair hearing? That then too Supreme Court gives him fair audience. But contempt proceedings, see, imagine a situation where courts are not respected. What will happen, my dear? No injunction order is obeyed. Right? No warrant is executed. No summons are executed. No order of any court is respected for one day. What will happen? What will happen? Revolution will come. Everybody will come to the streets with sticks and logs. Because there are good courts in this country, because there are good judges in this country, people believe in this system and no revolution is there. Right? Otherwise, the results will be unimaginable. Right? So, Supreme Court, in order to curb the delay of criminal trial, has passed, in Aman Kumar case, Supreme Court has said, we have to pass a pan-India order, how to curb the menace of prolonging the case under the guise of discharge. When Parliament has said there should be a time frame. Right? It is in Aman Kumar. Subsequent to Aman Kumar, this Aman Kumar was dated 29/10/2025. Please jot down the date. Then, in November 21st November 25, Supreme Court has listed the case once again for deliberating and passing a pan-India order, and finally it was posted on 21/7/2026. So, on hopefully 21/7/2026, Supreme Court will give guidelines which will be not enjoyed by defense counsels, but it will be good for a victim and it will be good for judges. It will be good for me also because I am a prosecutor now. Okay. Otherwise, in NIA court, see, we have to fight for 2 to 3 years for getting charges framed. Lot of petitions they are giving. One petition they are telling list of witness protection, and another this thing they are telling 161 copies are not there. So under some guise they are just moving some petitions. It is taking 3 years, 4 years for one charges to be framed by the poor judge. Defense counsel should see it from the other side. Right? Am I right, ma? Prosecutor? Whether they are allowing to frame charges. Whether defense lawyers are allowing to frame charge. No. We were also doing the same thing when we were on the accused side. Okay, yes. In another judgment regarding non-framing, the framing of charge, Dr. Anand Rai, Dr. Anand, RAI, Anand Rai, RAI versus State of Madhya Pradesh, 10/2/2026. Dr. Anand Rai versus State of Madhya Pradesh, 10/2/2026. Honorable Supreme Court has said, the spirit and substance of, please understand, spirit and substance of charges, framing of charges and discharge remains the same vis-a-vis the old law and the new law. That is, any case law which was applicable for CRPC on the question of framing of charge, discharge, is also applicable for BNSS. Only one thing is, it is tailored tightly now. Time structured tightly now. You understand, my dear advocates? See, every law that was governing the field of charge, framing of charge, discharge remains the same. That is, any judgment that the Supreme Court has delivered on framing of charge and discharge holds the field now. What is the only difference? Structured time frame. That is, you can play the game not infinitely, only in a limited this thing. See, previously when we were small children, we were playing in huge grounds in the school. Now our children is not playing anywhere, any ground. What are they doing? What your children are doing always? Sitting in apartments with one stupid cell phone. Any person who is now 35, 40 years, we all were roaming in the streets. No, playing multiple games. You do that, no? Whether your children are doing that? No children is going out. And everybody is looking like elephant. All children, no, now these days. All are bulky. During my school days, out of 60 children, only 1 or 2 will be bulky. And that boy will be cornered by every other fellow. Am I right, sir? It is the inverse now. Everybody is bulky or healthy, I do not know. Okay. Judge, I will give 3 interesting judgments for special court judges. Any special court judges here? Didi, you should help me now. Okay. Any special court judge can help, not these 2, because they have said, not these 3 judges, they have replied so many times. So out of game now. I have told you, in the magistrate court, framing of charges should be done within 60 days from the date of furnishing free copies. In someone's case, warrant case, right? My advocate friend should answer me, is there anything called as a sessions case, my dear? We have heard of summons case and warrant case. What is a sessions case? Whether any definition is there? Whether CRPC or BNSS has the word sessions case, defined the word sessions case? Yes or no? No or yes? CRPC BNSS has defined only summons case. What is a summons case? What is a warrant case? Right? We commonly use one name as sessions case. It is basically a warrant case that is being tried by a session judge. You understand, my dear? Understand that there is nothing, no definition, nothing is defined as a sessions case anywhere. Warrant case triable by a sessions court is called as a sessions case. Okay? Now special court judges should tell me one thing. I was telling you all this time, 60 days time for framing of charge under the new law is applicable from the date of giving free copies or the first hearing date in a sessions court. Okay? Right? That, see, we will go through the provisions first. You will understand. Tell me, how do a special judge compute it? See, you are a POCSO judge, right? Judges in the POCSO court, you give the free copies, right? How do you compute? How do you compute 60 days? Session judge, how do you compute 60 days? No, Ji, 1 second. I will take your help if required. I will read. Please come to chapter 19. There is a lacuna there. I argued in a case relying upon Orissa and Kerala judgment. I appeared in a sessions case. I appeared in a POCSO case as a defense lawyer. Okay. I filed an application after 60 days for discharge. The judge said you have come to court after 60 days. I went on and I said, why? She said you have come after 60 days. I told them a special court cannot calculate 60 days. I argued that you cannot calculate 60 days. Where from you calculate 60 days? Because, see, chapter 19, trial before a court of session, 249, opening case for prosecution. When the accused appears or is brought before the court in pursuance of a commitment of a case under section 232. Where is the commitment here? No commitment. Okay, so 232 is not applicable for a sessions case, for a special judge. Judge, am I right? Judge Sangma judge, am I right? Whether committal is there for your court, special court? No commencement. Within 30 days.
Within 30 days, you have to record the statement of the survival. That means the charges have to be framed much before it.
I will ask you one question. If suppose an accused comes and files a discharge application, and that is in inquiry, one side will you keep the discharge pending, another side you will comply with section 33, I think, 33 subsection 5 or something that. See, you've summoned me. On the date of summoning, I filed a discharge application, and it is a very interesting discharge that it could not be finished within 30 days. Whether pending discharge you will examine the complainant and record the chief examination.
We have to attend to the discharge petition first, because if discharge, then we will not be framing the charge. If we refuse the discharge, then only we will frame the charge. Then we will
what
proceed
happens to the
evidence.
30 days mandate?
Sorry?
Then what happens to the 30 days?
See, as we said, shall and may. So that is how the interpretation comes, because once the petition for discharge is there, we have to dispose of that first. Before going on to framing of charge, we can't frame the charge without looking into the discharge petition. So it's
Okay. Now tell me, see, now judge has said under 232, when reading 249, section 249 BNSS, there is no commitment of the case. Then discharge 250. The accused may prefer an application for discharge within a period of 60 days from the date of commitment of case under section 232. I am reading trial of sessions cases. POCSO Act says for trial you follow the CRPC. Bail and trial you should follow CRPC. There is no special provision in POCSO for conduct of trial. In POCSO, it speaks about how evidence has to be recorded, what all things has to be done, when the first examination should be made. Now, frame, charge and discharge, a POCSO judge falls under the chapter 19. Right? 250 says discharge. Accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under section 232. Now, I argued a case before my High Court stating that POCSO judge has to follow the procedure of trial before a court of session, because what is a sessions case is not defined anywhere. It is a warrant case. Trial has to be conducted for a POCSO, which is a sessions case, a rape and murder in a POCSO court. It's a sessions case. He is following chapter 19. If I come with a discharge application, he is telling me that you are on the 62nd day. I am asking him, how do you count it? Because 250 says you should count it from the date of commitment of the case. I am telling that you are a court of original jurisdiction. You've taken cognizance of the offense. Free copy was given to me long back by you. And can he go back to the second provision, coming to warrant case? Now come to 20. 20, trial of warrant case by magistrate. It is explicitly said 20 is applicable only for trial of warrant case by magistrate. Right? Coming down, 262, when accused shall be discharged, the accused may prefer an application for discharge within a period of 60 days from the date of supply of copies under section 230. Now, if you rely on section 262, then you are relying on a trial procedure. You are sitting in a sessions court, you are relying on a trial procedure of warrant case by magistrate. You understand, my dear? Making this tricky argument, right? In fact, this argument is not fair. But relying on this tricky argument, relying on some other two judgments which is in favor of me, I have won a case. I will give all the three citations now for especially special judges and for my advocate brother sitting there. You can go to the POCSO court and can frame a discharge after 60 days also, citing all these judgments and telling this, unless and until it is settled by some High Court judge or some Supreme Court judge. Okay? Brothers, have you understood? Putting it simply, in a warrant case before a magistrate, framing of charges or discharge should be completed within 60 days from the date of receipt of free copies. One thing. Coming to sessions court, framing of charges has to be completed. Discharge should be filed within 60 days from the date of commitment of the case from the magistrate court. This is normal CRPC and this thing. Special judge, he is a magistrate in himself. If he is conducting a sessions case, he should follow the trial procedures of a sessions case. In that discharge says, framing of charge and discharge should be done within 60 days from the date of commitment. Special judge does not have any other option. right? You take 3 judgments. Sajith versus State of Kerala. Sajith versus State of Kerala, 3/9/2024, Kerala High Court. Sajith, S-A-J-A-T-H, Sajith versus State of Kerala, 3/9/2024. Then Narottam Prusty, N-A-R-O-T-T-A-M, Narottam Prusty, P-R-U-S-T-Y versus State of Odisha, 22/9/2025. Then the case in which I appeared, N. Manish, N full stop Manish, M-A-N-I-S-H, Manish versus State of Tamil Nadu, represented by Inspector of Police and another, 16/2/2026, Madras High Court. N. Manish versus State of Tamil Nadu, Inspector of Police, represented by Inspector of Police and another, 16/2/2026. These 3 courts, high courts, have accepted that there is some doubt in this area and the legislature's interference is required. Okay? These 3 courts have accepted that there is some lacuna in this as to how a special judge should compute the 60 days because there is no commitment. If he follows trial of sessions court procedure, he is not a magistrate, he is not conducting a trial court, a session of a trial court, a session of a trial of a sessions case by following the procedure mandated by the magistrate. Okay? What is your answer? Any person, any trial, any special court judge, POCSO judges. What do you do if such an argument is made? How do you compute first 60 days? How do you compute? How do you compute? Yes, anybody can say. Please, ma. You can please sit relaxed and speak. Yes. Only teacher should stand these days. Kali Yuga, no? Yes.
Sir, POCSO is a special law.
Yes.
And it is providing 30 days. Secondly, it says that the trial
30
procedure...
days for what? 30 days
30
for
days
what?
for framing of charge.
No, it is 30 days for examination of the victim. That means before that 30 days, charges framing should have taken place as said by Sangma judge.
There is one more thing. POCSO Act provides that trial procedure of CRPC is to be followed.
Yes.
In the morning, we discussed that trial commences from the date of framing of charge. So prior to that, whatever procedure is there, for example, discharge application, for that purpose, the special law will prevail over the general law.
Special law, there is no procedure. POCSO is only taking, see, POCSO says, what is the word used in that? Law is not in derogation of any other law in the time being in force. POCSO, I don't remember the section correctly, section 35, Act is not in derogation of any other law for the time being in force. But it has specifically stated for bail and for trial, it should take the help of CRPC. Right? It has CRPC assistance is not oosted out. Right? However, how to compute this 60 days discharge? Hearing or charge. Okay, how do you compute it? You sit as a POCSO judge, as a session judge. G.
The CRPC will be applicable, the procedure of CRPC will be applicable. The crux of the problem is the computation of the 60 days.
Yes.
When
from? Where from?
Yes, from where it commences. So, there is no dispute that section 250 will be applicable. The argument emanates from section 250 that the period of, it is nobody's argument that period of 60 days or there is no time period prescribed. But if your argument is this, is that the time period has been prescribed, but the starting point cannot be determined. Now, there of course we have to understand is that you get the right to file an objection or to oppose the framing of charge from section 250. From section 250, you get your right to be heard before framing charge. Now, we have to understand it appears that your entire argument emanates from subclause 1 of section 250, which says that from the date of commitment.
Correct.
Now we have to understand that what do we mean by commitment, and why at all there is a commitment for a session trial. Now, commitment of cases is for the purpose of expediting the trial. So usually the session courts are meant only for the purpose of trial. All the process under section 207, where the corresponding section is 230, is to be taken care, secure the apprehension of the accused, and then send the case for trial. Now, under the special act, the special court is vested with the power to take cognizance of the cases or take cognizance of the offence without the case being committed. Now, it is not that the special court is not taking cognizance of the offence. There cannot be any trial without taking cognizance of the offence.
Correct.
The only thing which has happened is that earlier the cognizance was being taken by the magistrate and the case was committed. But here the special court is vested with the power to take cognizance without the case being committed. Now, once the charge sheet is filed, summon is issued. Now we have to find out when does the special court take cognizance of the offence. So it is not that the special court does not take cognizance of the offence. When the summon is issued, after filing of the charge sheet before the special court, when the summon is issued and you appear, and that is the point where the court is taking cognizance of the offence, and we have to understand the distinction between what does the word committal of the case signifies. So that is the purpose. When 207 is complied with, compliance of 207 is there with the special court also.
Correct.
So that will be a counter argument that section 230 has to be read it, and to give color to this justification will be, what you said is that looking at the intention of section 250 was basically to, as you said that in your words, to tailor out a structure, time structure. So that was the very purpose. But now, because of some ambiguity here, as we look in the apply the principle
literal
of
application.
applications, when you're interpreting certain provision of law, we have to look at the intention. The intention was to curtail. And that is where we have to understand commitment. And then not only that, we also have to understand is that why this power of taking cognizance without the case being committed is vested with the special court, is to expedite the matter.
And also special courts. But your answer is fantastic. Okay, I will give you more marks. Why? I will come later. See, out of the box she has explained very beautifully. I do not know how many of you has grasped. She told me, she caught me by my own head. She said, morning you said, trial will commence after framing of charge. In that case, you should not fall on see, you understand what she said now. She is telling, morning you said, trial will get commenced as per Hardeep Singh after framing of charge. Now why is that you are relying on provision? See, even though chapter 19, yes, even though chapter 19 is captioned as trial before a court of session, trial to be conducted by public prosecutor, opening of case, discharge, all those is under the caption of trial. She said, trial will commence only after framing of charge, as per Hardeep Singh. Now, POCSO says a sessions court should follow trial procedure mandated under chapter 19. If trial procedure has to be mandated under chapter 19, she is telling you should not follow the provisions of framing and discharge. See, charge, framing and provisions relating to discharge. Beautiful argument. Judge, you got the point.
Yes, sir. Got it.
Excellent point.
The main thing was, the whole question was about the cognizance and the commitment.
Commitment, not even cognizance, commitment.
So even in sessions cases, cognizance twice. Because see, it's very interesting because initially, if a police files a charge sheet under section so-and-so stating that, this sessions tribal offence has been committed. So the magistrate gives the 207 complies 209 and then says committed. Now, when the case comes to the sessions court is not going to be blind. The Sessions Court will look into the entire materials over there and then see again whether it is Sessions Tribal or not.
Correct.
If the court at that point of time feels that no, this is not Sessions Tribal, it can frame the charge and send it back to the magistrate court. Now the time frame that is given over here is from the date of commitment.
Commitment.
Date of commitment.
Yes.
So it is not the cognizance again, date of commitment, not framing of charge, of course, that's after.
No, see, the only thing now is we have played in the court, we are playing in the court on Orissa also shares a view, and Kerala and my court through me. Both the court, all the three courts have accepted that there is a lacuna in POCSO. But relying on what she said, see, she is basically telling one thing, trial commences after framing of charge. POCSO court has to follow the procedure of a trial court after the charges are framed. Don't look into the provisions which is before framing of charge. This is one beautiful argument. You can give a big clap for her. This is one nice judge. See, it is all as judge said, it is an academy where thought should flow. Secondly, POCSO says act not in derogation of any other law for the timing being in force. Suppose if charges framing, the provision as to commitment and framing of giving free copies, there is no bar that POCSO court can rely on the warrant proceedings. Right? If at all her arguments has to be taken, that Hardeep Singh says trial commences after framing of charge and POCSO court should fall on trial procedure of a sessions court, then trial procedure of a sessions court will commence only after framing of charge proceedings. Before that, a trial court POCSO judge can very well say, I have taken asylum in the procedure of a trial of magistrate court in furnishing free copy. Because POCSO Act says act not in derogance of any other law for the time being in force. That is, POCSO uses its own procedure. Now you should read section 4 and 5 of CRPC and 4 and 5 of BNSS. What is 4 and 5 of CRPC and BNSS? 4 and 5, every advocate who goes to a special court should read every day. Section 4 and 5 of BNSS or CRPC or pari materia, the same thing. What is that? Special courts are governed by special law. CRPC is the procedural law. Section 4 says CRPC is the procedural law for IPC offences. 5 says special courts are governed by special law and also by CRPC unless and until special laws oozed out CRPC out. Right? If CRPC is not ousted by a special court, special law, then CRPC will also walk along with special laws. See, understand things like that. These special laws were not there when IPC and CRPC alone were ruling the whole country. You understand, my dear? What are special laws? Over and above general law, there are two laws. Special law, local law. What is a local law? What is a special law? If there is one law for Manipur alone, then that is a local law. If one law for one taluk in Manipur alone, it is a local law. Right? If one law is applicable only to Pondicherry, it is a local law. If one law is applicable only to children, it is a special law. If one law is applicable to only women, it is a special law. DVC, Posh Act, POCSO, all these are special laws. See, if you using one dough, you make one nice dosa. What is the dosa called without anything? Plain. In Tamil, it is sada dosa. That was the general law. Right? Put some potato in that. What is that? Masala. Put some ghee in that. Not in that dosa, man. In a plain dosa, put ghee. Ghee dosa. Right? That. Like that, if a law is made to address one particular species, one particular problem, NDPS, special law, for a particular act by a particular governing narcotics and this thing, right? Like that, these special laws, you have one maxim, Generalia, specialibus, non-derogant. What is the meaning? special law will prevail over general law. Generalia specialibus non-derogant. That is, whenever a general law is holding a field and suddenly a special law comes in, general law will remain silent. Like you understand by an example. Who is the queen for your house? Before your marriage. I am asking boys, men. Who is the queen of the house before marriage of a man? Great mother. After marriage of you? Who is the queen? Amma, after your marriage, whether your mother-in-law is the queen, you are the queen. Give a big clap for her. Now she is the special law. She rules that house. In these special laws, there are two types, like arrogant daughter-in-law, humble daughter-in-law, ordinary daughter-in-law. Arrogant daughter-in-laws, the moment they step in, they will say, through a non-obstante clause, notwithstanding anything contained in me, no, see, if a daughter-in-law is so arrogant, a special law will say, notwithstanding anything contained in any other law for the timing in force, I am applicable for everything. That is, this special law will prevail to the whole extent. CRPC will not come in, IPC will not come in, any law, no law will come in. You understand, my dear? A special law, if it uses the word notwithstanding anything contained in any other law for the timing in force, it alone will rule. POCSO says, act not in derogation, and POCSO also says, for bail and trial procedure, you can take help from me. This is a daughter-in-law which says, mother-in-law, old, poor old lady, you also be there, I will also be there. But please give the key of the treasury to me. Almera key, please give it to me, I will be silent. So, some special law will say, we both will walk together. So, section 4 and 5 should be read thoroughly every day. Along with, if whenever you are dealing with a special law, you should see the non-obstante Worcester clause and also the non-derogant clause. Okay, for understanding all this, right? Yes. So, what is the answer? Your court has not faced any difficulty like that? Framing of charges in POCSO cases. Nobody has given an application to discharge after 60 days? Okay, I will tell the advocates to give the judgment. Okay, ma, yes. Next question, for judges especially. You framed a charge, right? Issued summons to the accused. After 3 days, you yourself think that I should delete a charge. Altering charges or modification of charges can be done at any stage till delivery of judgment. I am using a word, can a charge which is framed be deleted by the same judge? I am not, see, suppose you frame a charge under 307 or 326. You frame a charge under 326. During trial, you've come to a conclusion that it is 307, it is not 326, something like that, right? If it is an aggravated charge, then you should put notice to him that it is an aggravated charge. If the charge is framed, for example, Chandru kills his wife, simpliciter 302 investigating officer files, 302, right? Tomorrow, the trial court judge reframes it from 302 to 304B, which is lesser, which is greater offense, 302 or 304B. Advocate should answer. What is 302? Simpliciter murder. What is 304B? Within 7 years, by some cruelty, on suspicious circumstances, putting a woman to death. Okay, this is called as dowry death. Chandru's wife dies within 7 years of marriage. Okay, in a suspicious circumstance. Judge frames a charge under 302 IPC. During trial, he reframes as 304B. Whether it is becoming more grave, trial is becoming more grave or less? More grave. In a prosecution under section 302, burden of proof is not on me. You understand, my dear? In a charge under section 302, Chandru can stand with like a holy religious man, not opening the mouth from the beginning till the end. No need to let in any evidence. Nothing. Can stand like a statue, like God. Suppose 304B is altered, what happens? On the prosecution, making out a case, prima facie case by letting in evidence, I should give in rebuttal evidence. You understand? Because 113B, capital B says, court shall presume that he is the one who has committed the dowry death has taken place. When that presumption will come when prosecution has examined all the witnesses. And there are incriminating circumstances to be put to me under 313 questioning. Suppose in a 304B case, 10 witnesses, all turns hostile. IO also is very inefficient, he says nothing. There is no incriminating material as against me. Where is the question of me disproving something now? Nothing. So, see, discharge, framing of charge, deleting a charge which you have already framed, Supreme Court says, you can alter the charge and modify, you cannot delete the charge. Understand, my dear judges? When you alter the charge, if it is a lesser offense, then it is not causing prejudice to the accused, it is not a big thing. If you alter the charge where the charges are graver than whatever you have framed before, or if burden of proof is shifted on because of that charge, the burden is on the accused also, he should be given notice and he should start by putting questions in the cross itself such that rebuttal starts from that process itself. All these are too technical. I think I am loading much. I can see from the eyes. But my request is we should learn law thoroughly such that a healthy system develops. Just because we are now in the northeast of the country, it is not that we should not learn. But I admire the academy people. They are pestering me and calling. But I am also sure that within one day I cannot do full justice to you. Right? Yes. So deletion of charge is condemnable as was laid down by the Supreme Court. Judges are not empowered because a criminal court, any criminal court judge cannot review his own order. Adalat Prasad versus Ruplal Jain. Please write the judgment. Full bench, Supreme Court, Adalat Prasad versus Ruplal Jain, 2004 Supreme Court. Also read the judgment of Subramaniam Sethuraman versus State of Maharashtra, full bench. One is in August, another is in September 2004. Adalat Prasad versus Ruplal Jain, 2004 August Supreme Court, 3 judges. And Subramaniam Sethuraman versus State of Maharashtra, September 2004, full bench Supreme Court. These 2 judgments, full bench says, a criminal court cannot recall, review, drop the proceedings. He cannot recall and review its own order. Cannot drop the proceedings on its own accord. Once a discharge application is dismissed, once charges are framed, where the trial should end? See, brother, I am before a court of law. Judge is asking me whether you want to plead guilty. I am telling, no, you try me. Trial has commenced. Right? Can a court discharge me in between, or can I file a discharge once again? No. Once a trial has got commenced, like Vande Bharat, if it starts in Kanyakumari, it should go and reach only Kashmir. No stops in between. Right? In Adalat Prasad versus Ruplal and in Subramaniam Sethuraman versus State of Maharashtra, Honorable Supreme Court says, a criminal judge has no power of recalling and reviewing his own order. Like that, Honorable Supreme Court in Directorate of Revenue Intelligence versus Rajkumar Arora, A-R-O-R-A, Rajkumar Arora, 17/4/2025, Division Bench Justice Pardiwala's judgment, he has held that a criminal court which has framed charge has no right to delete the charge, however it can alter it. See, deleting it, completely removing. Once on the material you have imagined, you see, your conscience has said, yes, there is a material to frame. Suddenly you cannot become more wise. See, imagine a position where courts are given power like this. At your own whims and fancies, looking at the charge sheet, you've come to a conclusion, yes, I will issue summons to him, that charges are made out. For any reason, you can say that I am deleting the charge now, at any part of the trial. If charges are deleted, what will happen to the trial? Brother, what will happen to the trial? If no charges are deleted, charges deletion means nothing to be tried. So Supreme Court says once charges are framed, it can be altered or modified, but it cannot be deleted. You understand? Judges, you understand what I am telling? Yes. Are we following pre-trial conferencing here, judges? Pre-trial conferencing? You have heard something like pre-trial conferencing? Judge? Nothing. I will tell you 4 judgments, right? Where the Honorable Supreme Court has said a concept of pre-trial conferencing has to be followed by all the criminal courts in the country. From 2018, the Supreme Court has said every criminal court should follow a procedure called as pre-trial conferencing. That is, please listen, then you can judge. We were talking about this discharge and framing of charge, right? Once charges are framed in a criminal court, what is the next thing a judge will do? Immediately he will write one thing, like Sri Ramajayam. No, you will write something. Super. He is the one man who is talking the truth. On one side, charges framed, then list of witness, issue summons to LW 1 to 4, LW 5 to 6, then he will put a tabular date, isn't it? Sometimes in sessions cases, 4 days, 5 days we will fix, issue summons to LWs. Here, Supreme Court says in pre-trial conferencing, there is a triangular meeting, conference, there shall be. Right, in Karnataka, in Gujarat, in some parts of Tamil Nadu, they are religiously doing, because any order of the Supreme Court is not obeyed, one day contempt will fall. We do not know on whose head. Suppose a case goes to Supreme Court, where Supreme Court, some advocate like me says, my lord, this is a case where pre-trial conference is not followed by the judge. Then the question comes, why that state is not following? It says, after charges are framed, before commencement of trial. Morning we spoke about commencement of trial in Hardeep Singh. Now we have elaborately seen about charges framing. After charges are framed, before the commencement of trial, before the judge writes, charges framed, issue summons to LW 1 to 4, LW 5 to 7, 7 to 9, all this, the judge shall peruse, because while hearing on the charge itself, you have perused everything. Opening case of the prosecution has happened. This pre-trial conferencing is a developed version of opening the case for prosecution. Previously, some 20-25 years back, senior advocates, good prosecutors, who are even though politically appointed with some good brains, they will come and speak to the judge in the open court. They will say, my lord, this is a case of so and so. He has committed a crime. These are all the witnesses. 1 to 4 are eyewitnesses, 5 to 7 are Caesar witnesses, these are attesting witnesses, these are expert witnesses, these are doctor, these are this thing, right? And he will also say, these are the documents I am relying upon. Now the judge will ask the accused counsel, yes, when do we get along with the trial? What is the feasible date we will get along? Whether you have objection to all the documents that he has filed, what are the documents we can mark through consent? What are the documents we can mark, whether all these forensic experts should be summoned. All these had taken place 20-25 years back. Now what happens? A mechanical framing of charging. Nobody argues in discharge. Even discharge is filed. Nobody is allowing discharge application. Now trials have become mechanical. Now Supreme Court has said a pre-trial conferencing is a mandate on all the criminal courts, which is preparing a calendar of case management for each case. That is, after charges are framed, prosecutor should argue how many witnesses are there, how long he will consume, how many days he will consume, for how many witnesses, how many long hours he will consume, what are the evidence and documents he has got. Now the accused counsel will also be participating in that, and the judge. An agreement will be made in every case that this is how we are going to take the case. A defense lawyer has an opportunity there to apprise the judge that, see, 1 to 10 are eyewitnesses. I will not cross-examine the first to 10 witnesses, right? Individually, I will cross-examine all the eyewitnesses on one day or in given point of installment days. Now what happens? One man goes inside. The judge will say, yes, you cross-examine. Then this fellow will say, my lord, this is eyewitness. Second witness is also eyewitness. Third also is an eyewitness. Here the court says, Supreme Court says, you sit and talk as to how the trial is going to take and make an agreement. This tripartite agreement, all the three are bound. For example, I am a NIA prosecutor, no? I have now filed this pre-trial conference agreement. Why? Every case under UAPA, CBI will have 200 witnesses, 5,000 documents. At least a roadmap like this will show the judge that how many working days will be consumed for this. At least, in some probability, you will know that 6 full months should be dedicated for this case. Now, Supreme Court has said, and we are also doing, in Tamil Nadu doing, in Karnataka, from 2016, all criminal judges are doing that. And when I go to Karnataka Judicial Academy, this was a judgment written in Karnataka, CBI versus Butt. In the judgment is CBI versus Butt. A.V. Chandrasekharan, the honorable judge who has started this in Karnataka, is A.V. Chandrasekharan. Okay, CBI versus Butt, B-H-A-T-T. In Karnataka, they are telling disposal rate of criminal cases are more because, see, judge, there is one trap here. You think that you are trapping the advocate. Advocate is thinking that he is trapping the PP. PP is thinking that there is a net. Because, see, a defense lawyer who has committed that he will finish it within this time during free trial conferencing cannot go back. PP who has promised that I will produce all the witnesses like this cannot also go back. If they go back, 309 weapon will go to them. What will happen? If the accused counsel goes back, accused will go to jail. You will remand him because of non-compliance. If PP is not producing, then you will impose cost on the IO and the officers. Please read all these 4 judgments, and Academy should do something to implement this such that criminal cases should see the light of the day, at least. You will have a roadmap for each case. You are bound by that. Okay? You can take 4 judgments. Mallikarjuna Kodahali, M-A-L-L-I, Mallikarjuna Kodahali, K-O-D-A-G-A-L-I, Mallikarjuna Kodahali, through legal representatives versus State of Karnataka. 12-10-2018, Mallikarjuna Kodahali versus State represented by State of Karnataka, 12-10-2018. State of Kerala versus Rashid, R-A-S-H-E-E-D. State of Kerala versus Rashid, 30th October 2018. Honorable judges, kindly listen to me for 1 minute. Okay? Defense lawyers and police also. What is the directions in Rashid? Please listen. You will understand. Under section 230 of CRPC, please listen. A trial program is generally prepared on the application of the prosecution. The following practice guidelines should be followed by trial courts in the conduct of a criminal court as far as possible. 1. A detailed case calendar must be prepared at the commencement of the trial after framing of charges. Right? First point. Second point. The case calendar must specify the dates on which chief examination, cross-examination, if required, of witnesses to be conducted. In that itself, PP can say, 5 eyewitnesses are there, I am going to examine only 2. Now you will know that all the 5 may not be examined. Suppose if these 2 eyewitnesses, LW1 and 2, are turning hostile, this man now will make an application, consider the third one. Otherwise, going through the list of witnesses, mechanically what we will do, LW1 to 5 on one day, 6 to 10 on another day, 11 to 15 on another day. You are going without a GPS system, right? Then the case calendar must keep in view the proposed order of production of witnesses by parties, expected time required for examination of witness, availability of witness at the relevant time, convenience of both prosecution as well as defense as far as possible. Then, fourth point, testimony of witnesses deposing on the same subject must be proximately scheduled. See, this is more scientific. Rather than groping in darkness, no, he coming and fighting every day, you can sit aramse stating that, brother, take the tripartite agreement, you have accepted like this, we are moving through this. Right? Then the request for deferring the case, that should not be entertained as per Vinod case. Vinod Kumar is a state of Punjab, 2014. All prosecutors should have the judgment with you and all judges also should have. In private complaint, you can have for fighting with the other party. Vinod Kumar is a state of Punjab, 2014 says, chief examination of every witness in a criminal case should be completed on the same day. Cross has to commence on the same day. If cross cannot be finished on the same day, it should continue on the next day. Suppose a witness is available, chief is made, not cross-examined, time required, seek for a deferral, after 2-3 months, the same witness comes and turns hostile. What is the implication? What is the implication? What was the implication? A witness who said the truth 2 months before, accused counsel has not cross-examined. After 2 months, the witness comes and says, no, I have not stated like that, I have not seen him. Then what do you understand? He was win over. Vinod Kumar of the state of Punjab says, on the date of chief, if accused counsel willfully absented or willfully restrained from cross, after some time if the same witness comes and deposes, turns hostile, remove the hostile evidence, take the chief examination and convict. Okay? This is Vinod Kumar versus state of Punjab. A witness was won over by a defense, by purchasing time, by not making the cross-examination on the same day. The evidence in cross of turning hostile should be achieved and this has to be relied. This is in Vinod Kumar. Right? Here, Rashid case court says the request for deferral under 231 subsection 2 must be preferably made before the preparation of the case calendar. Here, while making case calendar, the accused lawyer will say, you have to defer the cross of these persons. I will cumulatively make the cross-examination of all of them. So, an advantage for defense lawyer is, at the time of making calendar itself, you can say, which witness, when are you going to examine on a more scientific line. If you avail this, then Vinod Kumar probably will not come in. Right? So this is advantage for you also. Then the grant for request of deferral must be premised on sufficient reason justifying the deferral of cross-examination of each witness or set of witnesses. Right? Then, while granting then case calendar prepared in accordance with the above guidelines must be followed strictly unless departure for the same becomes absolutely necessary. Should be followed strictly by all the three. Then, in case where trial court have requested a request for deferral, necessary steps must be taken to safeguard witnesses from being subjected to undue harassment, influence and intimidation. So, Supreme Court has prescribed a thing which is called as pre-trial conferencing, that police people also should insist your public prosecutors, after charges are framed, PP should file an application stating that, a simple application for pre-trial conferencing. All the courts are bound to do that in view of the guidelines of the Supreme Court in Mallikarjuna Kaudahalli was a state of Karnataka, Rashid was a state of Kerala. Then another judgment is INRI, assessment of criminal justice system. INRI, assessment of criminal justice system in response to sexual offences. 18th December 2019, INRI, assessment of criminal justice system in response to sexual offences. 18 December 2019, then INRI, next INRI, issuance of certain guidelines regarding inadequacies, INRI to issue certain guidelines regarding inadequacies and deficiencies in criminal trial versus state of Andhra Pradesh. INRI to issue certain guidelines regarding inadequacies and deficiency in criminal trial versus state of AP, 2021 judgment. Okay. All these 4 judgments, Supreme Court is repeatedly giving reminders to the criminal court from 2018, 19, 20, 21. One way of getting out the hurdle of delay in criminal trial is to follow the pre-trial conferencing. Supreme Court uses the word, all the criminal court shall hold a pre-trial conferencing. So it is basically the duty of all the judges to definitely follow this. Okay? Yes. Then we will come to new criminal laws. We will just digress for a moment. We will come to the directions of the Supreme Court in Ajmal. Okay? I will ask a question, right? Whether you have this Dowry Prohibition Act here? No? Yes? Okay. What is dowry? Is it a gift or a demand? If a boy becomes a judge, then the girl's family should bring more this thing, isn't it? See, I remain as an advocate. What is the gold that I can demand from the girl's house? Comparing to a judge. Gee, who demands more dowry? Well-educated and settled man or a poor man? Well-educated and settled man's mother will become more greedy. Right? Not a poor fellow. A poor fellow, poor man is incapable of getting a woman at all. Then how dowry? So it is basically a special crime committed by rich persons. Right? Like multi-speciality hospital. Right? Have any one of you judges passed order under Section 6 of the Dowry Prohibition Act? What is Section 6 of Dowry Prohibition Act? You should pass an order of return of all this. Now it becomes a proceeds of crime. Whenever the court finds a person guilty, judges should listen. And all of you also should listen, because if you appear for the other side, you will file a petition. Whenever the court finds a person guilty under Section 2, 3, 4, 2 is the definition, 3 and 4 of the Dowry Prohibition Act, court should pass an order of return of that articles. You understand, my dear? Have any one of you done like that? Why? Why? No case.
Very less, because here on marriage, the man goes to the wife's house. The majority of the population. He doesn't really carry anything with him, but whatever he earns goes to his wife as well.
Didi, I want to hear the other side from you. Is it true? No case of dowry. Had I known 25 years back, I would have married a girl from here. Now it is too old, late and too old also. Right? Yes. Okay, see, any demand before marriage, during marriage, or after marriage from the wife or wife's relative of any valuable security is a dowry. Okay? Is it a pleasant thing to compel a woman and woman's family? See, firstly, we should think that we are not purchasing pork or beef or mutton or chicken. Understand? We should imagine, see, we should not think that we are purchasing 50 kg of beef or 50 kg of pork or 60 kg of pork. It is a human being from a other man's house. Right? You have no authority of harassing a person. See, imagine a father who has grown up the daughter. Up to 20, 21, 23, 24, this child was playing very nicely and happily with a person, a father and a mother. Right? You are not purchasing that human being. You can never purchase a physical, you can purchase a physical body. You cannot purchase the love and affection, soul in it. So don't think that the moment you tie some nonsense on the head or put something here, you have purchased her. How do you believe? How do you behave? You behave like a king. Array, what are you doing? Will you not come and remove my shoes? Will you not come and give a cup of water? I am coming from the court arguing a case. I have delivered judgment. You are not giving anything. See, all these dramas, no, will not work for a very long time. You start loving a woman, don't compel a woman to give something. See, whenever a man or a man's mother compel a wife, a daughter-in-law to give something, it is more cheaper and lesser than begging in the streets. Right? You are commanding something. It is more uglier. That man at least, no, he with courage is projecting to the world he is a beggar. We project as X and Y and commit an atrocity of demanding, thereby begging to your wife who has given you all pleasure, who has given you all her, blood, soul and everything, who has given a good child for you, then to compel a girl child who is not your property, basically belonging to other family. See, it is like purchasing a plant from what is the nursery? You see, you go to a nursery today, look at a plant. How plants will be in nursery always? You look at a plant in a nursery, how it will be? How it will be? Very dull, infected. It will look very nourished, happy, like you go to a father-in-law's house before marriage, how the girl looks. The moment you take her and torture, she becomes a dead plant. Right? It is basically uprooting a woman from other man's house. She needs lot of love and nurture as she was enjoying in that house or better than that. This whole case of state of UP versus Ajmal beggars, a girl child was given in marriage in the house where she has come. The man there and the man's father and the man's mother tortures her for bringing more property, a TV, a refrigerator and a motorcycle. Right? A TV, refrigerator and a motorcycle may look very minimum for Chandru. May look very menial for Chandru. That is what in the morning Honorable District Judge said. Sitting in a High Court or a Supreme Court or a judge, you will not understand the pain. Sometimes 500 rupees is like a Himalayas for a man who is in a tribal area and begging with somebody. You understand, my dear? In this case, if this case is read by a normal man, what is this? One TV, one motorcycle, one refrigerator. Right? This girl could not address that issue. She goes and weeps with the parents. 4 to 5 times she goes there. Parents says, Ma, where is the money? What we have? We are all coolies, we don't have anything. So every time she goes back. Right? Now what has happened? This girl was beaten by them and poured kerosene over the body. She got fully burnt, and the room in which she is residing also got fully burnt. Right? During the trial, PW1 is the father-in-law. PW mother is the mother-in-law. Of whom? Of the accused. Who are the accused? Husband is the accused. Then husband's father, husband, mother are A2 and A3. Okay. Now, during cross-examination, the husband's advocate asked 2 or 3 questions, very tricky in nature. Whether your child was living happily there. See, these people are illiterate, rustic people. They will naturally, yes sir, she was living happily only. So PW1 said she was living happily. PW2 said, mother-in-law also said she lived happily. Alright? Trial court convicted all the 3 for 304B, for 306. What is 306? What is 306? No, I am sorry, 304B and 498A. What is 498A? 498A, IPC. Cruelty or harassment by husband or husband's relative. And husband's relative or husband's relative. Okay. Now, PW1 has stated a long story. What is it? I gave in marriage, my daughter came weeping, my daughter said they are demanding all this. All this is in chief examination. In cross-examination also they repeated the same thing. One word, when a suggestion was put, whether your daughter was happy, yes, she was happy. This one word was taken by the High Court of UP Allahabad. High Court judge has written a judgment acquitting these fellows, all the 3, stating that PW1 has admitted that I am happy. PW2 mother-in-law also said that the girl's father and mother both said she is happy, so I am acquitting. This is called as relying on an outlier record, outlier evidence. OUTLIER. This is called picking and choosing one word from a bundle of facts and seeing it through a magnifying glass is called as relying on an outlier evidence. Supreme Court said this girl father has wept, girl's mother has wept. In evidence they have deposed across the chief and cross everything. Using one word for an acquittal, and see the fun part of it is, the High Court judge writes, the husband would not have demanded a motorcycle because father-in-law and mother-in-law have said, son-in-law do not know to ride a motorcycle. 2, they are very poor people, so they do not know how to operate a TV and a fridge. The High Court judge writes, reasons for acquittal is, demand of dowry cannot be proved because they are very poor people. They would not have asked a TV because they cannot operate a TV. He himself writes. He says they are very poor, they would not have demanded a fridge. Right? 3rd, he says, the father and mother of the deceased have accepted that she was living happily there, so I am acquitting. What your conscience says. There are witnesses to say, we saw the father-in-law and mother-in-law and the husband running out of the house. Now Supreme Court judges are asking to themselves that, had there been any effort to any of these people, they would have sustained at least some injuries. Nobody has sustained any injury. One child has died charred to coal. Right? The whole edifice gone to burn. But then a High Court judge has no sensitivity. He wants to acquit those persons. He himself emulates reasons and rights. This insensitivity of Justice Sanjay Karol and Justice Koteswar Singh has given a direction to across the country that if women are treated in this country so badly, see, think of a place, now see there are a lot of women and a lot of men. Unless the mother in the house is very rich, in the sense well cultured, well nourished, well respected, then if one part of the body is not respected, then what is the shame in having other part of the body? So this judgment is basically from a good-hearted man, Justice Sanjay Karol, a very, very good person, right? When I went to Manipur, Justice Sanjay Karol had come along with his wife. I had seen him, a very wonderful human being, who respects his wife much, who loves his wife very much, right? I had seen him. I do not want to elaborate much on that. A wonderful person, a well-cultured person. And Justice Koteswar Singh, equally, he is from Manipur, excellent human beings. It is the judgment authored by both these judges. And this judgment says, woman in this country has to be respected. If any harassment to any woman, right, takes place, then there are evidence on that. See, always remember that no Supreme Court is directing you that if a case is filed, then put the man into jail. It says that when there are evidences staring at your face and flying across, if you show a blind face for that, then it is atrocious. No. Now think of, it got acquitted. Like morning I said, no, Kishan Bai's case, it got acquittal. Now think of the girl's father and mother. What they will think? This has happened 20 years back, 25 years back. Went up to Supreme Court. Had the Supreme Court, like High Court, said, yes, poor people will not demand dowry. And a poor man do not know how to drive a motorcycle. Just where from they are getting all this? I do not know which imagination propels them to write like all this. They are not gods. They are all judges of court of law, bound to only rely upon evidence and to facilitate either acquittal or conviction from evidence. Okay, honorable judges, now the time is for, I am here only tomorrow afternoon I am leaving. Anybody is interested in asking any question, don't ask. See, one girl, a law college girl, I asked, you can ask any questions, 10 years back. I was having still a longer hair. And in law colleges, you have to write like this. No. I said, anybody, any question. A girl, I cannot forget two events in my life from law college. One small boy, little boy, 15 years back, he asked me a question. Chandru sir, you are here to explain on criminal cases. You are telling us you should understand each word. You have explained what is crime, what is criminal. You have not explained what is criminal case, that CASC. How to explain law college student what is a case? None of us can imagine that we are intelligent. We are a dust in this big legal ocean, right? Worse than a dust. My senior will always tell me, Chandru, never get inflated by anything. We are not even worth of a speck of a dust. We all learn every day, right? I also learn from you many things. Many honorable district judges have taught me today how to be courteous and what is ethics, right? What are values? I learned from them. You tell me now, anybody from the hall, a law college boy, small boy asked me, tell me what is a case. Define me what is a case. He asked me further, in which law it is defined. CASC, civil case, criminal case, every judge uses the word. Arey, case is called, where is the advocate? Now the client will come running behind, sir, case is called, sir, you are not coming. What is this word case? Where it is defined? Which law? This question was put to me by a law college boy in a law college, in a law class. 60, 70 students. A professor like Didi introduced me as gold medal law and gold medal in law, gold medal in BA, all this thing, all dramas, right? There are 60 boys in my college and I am the healthier fool there. So I was given a gold medal, that's all. Pondicherry has got 4 or 5 colleges, so getting university medal also is not a big thing. I have not got a medal from IIT, right? A small boy is asking me a question like this. Tell me what is a case, where it is defined. I took 3 days, honorable judges, for finding out the answer. 3 days. I went to my senior, cried like a small boy. I said, I was put to shame. She said, no, you are learning. They have taught you to learn better. That was my senior's answer. I said, I am ashamed. All the 69 laughed in the class. Madam said, nothing. You should never have an inflated ego. A teacher goes to a class for learning and learning. That is what my senior said, learning and learning. If at all I am a fool, I should learn from something. I should unlearn. Right? Then the answer is Bimmappa, Basappa, Bhusanavar versus Lakshman, Shivarayappa, Samagauda. Class is not concluded by telling some Vedic mantras. Bimmappa, Basappa, Bimmappa, B-H-I-M-A-P-P-A, Bimmappa, Basappa, B-H-U, Bhusanavar versus Lakshman, Shivarayappa, Samagauda. 1970 Supreme Court full bench. Bimmappa, Basappa, Bhusanavar versus Lakshman, Shivarayappa, Samagauda, 1970 Supreme Court. Honorable Supreme Court has given a judgment stating that word case is not defined anywhere. I could have said this to the boy. When that boy asked me where is the word case defined, like Supreme Court has said, I should have told him, no, it is not defined anywhere. It is not in CRPC, it is not in general classes. I have not said, but Supreme Court has said the word case, where it is defined? Not defined anywhere. This was a judgment of 1970 Supreme Court. However, the Supreme Court says, even though it is not defined, Supreme Court has attempted to define as in normal context, in a normal criminal context, the word case in criminal context has to be understood as a process which ends either in a discharge or an acquittal or a conviction. This is the definition of the Supreme Court for the word case, especially in criminal context. Okay, this is one thing. One boy, one girl, law college girl, right? And I was writing something, finished the session. Previously, no, it is in Pondicherry, it is not to Meghalaya. Pondicherry, you have this much of hair, what will happen? It is a very warm place. Going and taking in a class where there is no AC, government college. I prefer to go to government colleges. Why? Well-paid colleges, they have good resource person better than me. For government college, you should have a sincerity that I should see to that those children also come up like that. One girl, any time I go to a class, I unfold that, right? She said, Chandru sir, how is that you are growing such a long hair? What is the oil you are using? I said, no oil, no worries. Right? Now come to the real questions. Answers are not guaranteed. Okay, any question you can ask. Ji, give the mic to him. I will tell my number and phone number also, name and phone number. If there is no time, right? If I cannot answer also, I will just reply. Any legal question you can ask with me.
It's on section 223, subsection 1, proviso, which we had dealt with this morning.
Ji.
In this case, earlier, before the
new law,
the cognizance of the case could be taken up without hearing of the accused person.
Yes.
Now, in the new law, hearing of the accused person should be done. Now, in the morning, you have taught us that the court will issue summons only after taking cognizance of the case. Now, how to, without issuing of summons, how to make the accused persons come to the court so that the court will have the chance of hearing, given the opportunity of being heard. So some kind of letters or summons should be issued to them, then only they will come.
Are you present in the morning?
Yes, I was there.
I said you should not issue summons. I said court should give him a notice.
Notice. So that will be termed as notice, not as summons.
Yes. I have told, no, in detail we were discussing about this.
Okay, in that case, that's done. Then the next,
you
on the same topic
one
only?
second.
Yes.
Kaushal Kumar Agarwal. Kaushal Kumar Agarwal versus Directorate of Enforcement. Kaushal, K-A-U-S-H-A-L. Kaushal Kumar Agarwal versus Directorate of Enforcement.
Sir, on the same topic, I would like to ask another question.
I am just 1 second, Ji.
Okay,
Yes,
okay.
I am ready. I will answer any questions, right? Kaushal Kumar Agarwal versus Directorate of Enforcement is a judgment of 2025. In this judgment, the order, please read this judgment also. It is exactly what the question is asking. Here also in PMLA matters. I told in the morning that this is not for general law offences. Even some courts, if they entertain a private complaint by way of, even special courts, if they entertain private complaint procedure, not only magistrates, even district judges, even for, this is a PMLA case. Directorate of Enforcement is PMLA case. In this case also court said, once a complaint is presented to you, you should examine the complainant and the witnesses. Thereafter, instead of a summons, you should issue a notice to the accused along with the copy of the complaint and the witnesses. It is not deposition. It is statement made by the witnesses, because if it has to take the color of deposition, then evidence has started. During evidence, deposition is recorded. Right? These are all statements given to the magistrate on oath for the magistrate himself to satisfy that now I can issue a, previously he was issuing summons as rightly asked by the president. Now it is the notice only for the limited purposes of what? What the judge does? Accused comes, accused is, I told you, it is like hearing, exactly. Like during the discharge application, the judge hears you. It is exactly the same. The accused will be heard. It is through the process of notice, even for special offences. Okay, please read this judgment. Very excellently written judgment. Yes, Ji, please.
Sir, now after receiving a notice, the accused comes to the court. So whether the magistrate concerned will ask him or her to submit a written statement,
What
or
is the answer?
whether only his verbal statement
What
will
is
be
the
taken.
answer? I have told you. What is the answer? I have compared this procedure with what procedures of CPC? Order 7? Rule 11. What did I say? A defendant cannot file documents in a rejection of plaint application. Like that I told you. What did I say? In a discharge application, it is limited only to what? To the FIR till charge sheet. If I want a judge to discharge me, I cannot rely on my own documents. Relying on documents will come at the stage of evidence. Vijender versus NCT Delhi. Vijender, Vijender, Vijender versus NCT Delhi. Vijender versus NCT Delhi, the Honorable Supreme Court says, materials collected by the police, see the words. Vijender versus NCT Delhi, Supreme Court says, materials collected by the police by way of investigation, because under 2H of CRPC, what is 2H of CRPC? It defines investigation. It says collection of evidence by police. It is not collection of evidence. Evidence is the one which is led in the box by the witnesses. You understand, my dear? Vijender says materials right from FIR to charge sheet should be translated into legal evidence in the box. I am repeating, materials of police, 161 statement, confession, seizure, this, that, all this has to be translated into legal evidence by the witnesses as oral evidence. Displaying of documents will become documentary evidence. A document or statement will get the sanctity of evidence where? Any document will become evidence where? Automatically it will become? No, in the court. If it has to become a evidence, there should be a chief examination and that oral evidence should be subjected himself to cross, display of documents should be subjected to cross. Only if all these rigors are passed, then it becomes an evidence. So per se, a paper, how much our sanctity it becomes, 164 CRPC statement, confession before a magistrate, statement before a magistrate, nothing will become an evidence per se. It is all material, becomes an evidence when the author goes into the box and deposes after a oath. Only after deposition oath, a statement becomes an evidence, right? Like that, in 223 also, private complaint also, the complainant should go to the box and the witnesses will go to the box. But because it is not a trial, it has become in a pre-trial stage, the word used is not evidence, it is a statement. The complaint and the witness's statement will be given to the proposed accused with a notice. That man will come, he will be heard by the court. What is the exception that I have said? Who can come with a report in a private complaint? In a private complaint, I said, if it is filed as against a public servant, the public servant accused will come to the court, he will be heard, his superior will file a report. That superior can bring all the records and that the records can be displayed before the court, but not the accused. Accused has only a right to be heard. He will not submit any paper, any material to the court because the domain changes. Which domain? Only during evidence, during the stage of his case, he can produce documents, or he can produce documents to cross-examine the prosecution witness. You understand, my dear? See, I am working here, right? Didi has given a complaint against me that Chandru has slapped me by 340 or 440. It is getting recorded, right? If she goes and files a case that Chandru has slapped me, will police take a FIR or not? Didi now goes to the police station, makes a complaint that Chandru has slapped me and pulled my chain. Whether it is a cognizable offense or not, cognizable. Then I came out on bail, told the police that it is all recorded, please take it. He has not bothered. Second question is, during discharge, can I go and file this record to the court and say, see, you leave alone the prosecution material, I am producing a material from my side, you consider that and discharge. Can the defense produce any document during discharge? No. Settled proposition. You cannot do that. Right? An accused can produce a document or evidence in a criminal trial either during the defense stage or when Didi is in the box after chief examination, during cross, I can ask her, Didi, what is the day when the incident has taken place? What is the day? It is on 13/11? 12/11 or 13/11? Today? 13/6. Yes. I will ask a question, where were you on 13/6? She will say in Judicial Academy. Where I was? You are also in Judicial Academy. Whether any video recording has taken place? Yes. Whether that video recording has a GPS in it? Yes. What is GPS? It is the positioning, geocentric positioning with the timing. Okay? Yes. Now I will display that in the cross. See, this is the photo, this is the videograph wherein you have alleged that I have assaulted you by 340. This is the videograph played from 310 to 550. Nowhere I am near you. Even by 450 you are wearing a chain and you are sitting composed. But I cannot do this, I cannot produce this better evidence at the stage of discharge. This is the law of the land till date. Okay, any other question?
Sir, I have not completed. I have one more question on this same topic. Now this new criminal law has been made with a view to bringing faster justice. Now, under section 223,
yes.
When an accused person has been issued notice, he comes to the court, but he engages a lawyer, and they take adjournment, And after that, magistrate also, for some reason, he or she takes a leave.
Yes.
Then it takes a longer time. But, the justice is delayed. Now, actually, it is, the purpose of making new criminal law is being defeated. So, is there any time frame when the hearing of the accused should be completed?
Correct. Good question. For this also, I told you the answer. Why 223(1) proviso came? What is the judgment I said? Told you two judgments. Priyanka Srivatsa was a state of UP and Ramdev food product was a state of. You should eat more herbs. Gujarat ma. Yes. Pokso judge is more intelligent and having good memory. Our president, bar president, is worried about two things. One is 223 proviso 1 says accused should be heard. Now the Supreme Court has thought it fit that an innocent person should not be harassed by way of a private complaint, issuing notice to him in the name of accused, right? You cannot issue a notice to him, bannering him, labeling him as accused. Now he is called, if the magistrate hears him or the special court hears him and gets convinced that it is a false case, there ends the harassment for him. At which stage? Which stage? At the threshold initial stage. If such a procedure is not there, imagine any person can file any private complaint on anybody. What is the only thing? He should nicely draft it, such that the magistrate will believe, how many cognizable offences are made out here. Second thing is, if a judge is on leave, how many judges are on leave across annually but for maternity leave? Right? Judges are also human beings. Comparing to the adjournments which we get, the leave of the judgments are insignificant. Okay, so President, I am against you in that. Judges are poor judges. Right? I addressed all this in the morning. See, I started with the session like all the stakeholders are important for the delay. Every one of us are important for the delay. Very frankly, I said, while I was an accused counsel, I was doing all tactics. Right? When I am the prosecution said, I will do some tactics. Over and above all, an intelligent judge with integrity, with no forward looking. Right? What is forward looking? That I should compromise everything. My goal is only that white building. Right? If you are forward looking, the conscience gets crumbled. Whatever is in our hand today, whatever is God's wish, have a rich conscience, and every one of us should be accountable for ourselves. Right? Then the system will see all this is in paper. The constitution, if this book is a constitution, is a bundle of paper. Give this constitution book to your child, 1 or 2 years old. What it will do? A 2 years old child, what it will do with the constitution book? It will piss on it. It will tear as if it is tearing any other paper. Give it to a man with good conscience. What he will do? What he will do? He will uphold the constitution, right? Any bad constitution in the hands of a good judge, any bad constitution in the hands of a good judge will become a nobler book. Any good constitution in the hands of a cunning person will become a paper not worth of the print in which it was made. Right? So it is basically not the statute. Any amount of BNSS with any amount of amendment comes in, unless we get ourselves what? Baptized with holy water, nothing is going to change. So with positivity, we'll finish it. Any other questions? I will tell my phone number. It is 98433 22533, right? If it is any questions on law, my time is very, very deficit. I will try to answer. Right? Yes. 98433222533. 98433222533. My name is E.V. Chandru, E.V. Chandru, Chandru, Advocate of Madras High Court. Right? My prayer is, what will be my prayer? We are all in one position, a very nobler position. Right? Look the poor people around in the farm, in the field, on the roads, taking luggages, right? God has given you good health. Good health is the greatest wealth. Right? Beyond good health, have a very pure heart. As I told you, death will come and take us at any time. Right? Be good unto yourself. Love your children in home. Don't project yourself as Hitlers in the home. Don't carry that judgeship, that policemanship inside the house, in the place where you are living, because the day you retire as a human being, right? Not as any post. You will find the difference. Post-retirement, if somebody loves you, you can imagine that you have behaved as a good person. What is the yardstick? With post or the horse, the post, people should admire you. So post is immaterial. Behave as a good person. Okay, I love you all so much. My thanks is to my senior who has taught me law. If anything is appreciable or useful here, credit should go to the God who has taught me law. That is my senior in profession, Mrs. Vrinta Mohan, and to my parents who gave the body and a good health. Right? If any nonsense is spit by me, kindly pardon me. And if something unworthy of it is taught also, pardon me. I apologize for that. Thank you so much. I love you all. Right? Thank you, Didi.
That was a very enlightening 3 sessions for today. So on behalf of the Academy, I would like to extend a very warm thank you to Mr. Chandru sir. Yes, a big round of applause. I think he deserves all that. Briefly, when we had you in the Academy 2 years back, the new criminal laws had just come into place, yet to be implemented. And as the Academy, when we were looking for resource persons, we were having many questions, in fact, because we did not know who to call, or rather whom to call. Because being new criminal laws, having good resource persons on the subject matter is a challenge, because the experience was not there, the practice was not there, everything was new. So we were wondering how can we take forward, having an orientation program on the new criminal laws, because all the judicial officers, the lawyers, the police officers were to be sensitized on the new laws. But thankfully, because of my meeting with some of my colleagues in National Judicial Academy, they recommended your name, and it is without regret that we were happy and privileged to have you with us. In fact, you had fulfilled your task to the maximum, and we were very much enriched by whatever that you had shared with us. And after that, we were even more certain that we will be calling you again. So now, after 2 years, so we thought that we need to have a refresher course, because we thought that a refresher course will be like a booster shot to all of us to help us retain whatever that we know, and at the same time to address the loopholes and the gaps which we have faced for the past 1.5 years, and at the same time to encourage us to learn and to keep us on our toes on what we need to comply, what are the guidelines. Thank you so much for sharing with us. It is without any reservations that you have shared whatever that you have. In fact, we are all in awe at the content and the photographic memory. And
I'm not married, no?
so less stress, less tension. But thank you so much. And from the Academy side, we would like to extend a warm gratitude to our Honorable Chief Justice, because she was very happy that we were having this. In fact, when I mentioned your name, I could see that she was very familiar with your name. And in fact, she was watching this whole program because we had live streamed it. So, and of course, Justice, thank you, who's the judge in charge of the Academy. He's always been instrumental and always supported whatever proposal that we place. And Justice Dingdo, let me just mention that he had volunteered to come. Yesterday, he called and he said, I want to attend because there are certain things which the High Court needs to know what happens at the grassroots level. So he was here, but being a working day today, they could not be here the whole day. A gratitude to Dr. Sacheng, because he was the one who coordinated with all the districts of the police, and we were able to have the attendance of so many police officers because of the coordination and the support that we received from Dr. Sacheng. And of course, the district judges, all the judicial officers. In fact, we were scared that they might not come from Garo Hills because of the scheduled meeting that was supposed to have, or rather, you were supposed to have some meeting yesterday, and some of you had expressed concerns that you will not be able to travel. But fortunately enough, they were able to be here. To all the lawyers, the members of the bar associations, for sparing your time, because we feel that to miss out on a session with Mr. Chandru would be a big loss on your part. So thank you once again to the staff of the High Court, the Office of the Registrar General for allowing us to use the auditorium, the staff of the Academy, and all the support staff from the Highland Studio for doing the coverage. Thank you so much. And before you leave, please take your certificates from the staff station there in the lobby. Thank you.
Thank you so much. See, I should thank her, and it will be good if somebody gives a feedback. One judge and one police and one advocate, somebody.
Yes, someone
And,
can come and
can give a feedback, and if there is any difficulty in understanding or anything you want more or less or something, I think some good feedback is required.
yes, anyone from the police department?
Can call
And from this side,
from
the
senior
lawyers
judges
or
and
the
some
judicial
young
officers?
judges.
From the police, anyone can come? Because I've
Somebody should
noticed
give a
the moment
feedback.
sir mentioned the telephone number, contact number, you all took it down. Yeah.
That you also should
Yes.
come. And some advocate friends, especially
Additional
girl
SP
child.
of Ribhoy, Mr. Masar,
It's no girl child is
and
coming.
District Judge Joy.
Thank you, sir. In the midst of so many judges, it is always very intimidating to speak, but considering that me and Gil were only there, I think there was no choice. I had to come. So I thank you for this opportunity, sir. I've already noted down your number. I am Orville Masar, the tall one. I will mention if I call you. And I will do indeed need to call you one day, because in the district affairs, there's so many problems that are ongoing, many issues that we currently know of, and many issues that we do not know of, that we will indeed need your help. And we thank you, say thanks to the Judicial Academy for organizing such a... This is not my first training program. I keep giving my name, actually, for each training programs that are being organized. So I'm very thankful. And there's not much, actually. I'll give a time to somebody else also to speak. I thank you to the judges who have organized, Madam, who's always in touch with me for many things, always giving me the updates on the next training that is to be organized. I thank you again, sir. Thank you, sir. Thank you again, and I will be in touch, sir, for sure.
Definitely.
Thank you, sir.
Thank you so much for giving me this opportunity. And in fact, to sum up and to make comment on such a wonderful talk, I can say, because I believe as a judicial officer, we are not very comfortable with when we say that we have to undergo training. All right. So sometimes it says that, there's a lot of shortcomings in our officers and we need to be trained to become better officers. But coming back to the program, one thing I need to congratulate sir, that we started our day at around almost 10, and we are at around 4. So it's not easy to keep all
We are
the
at
judicial of 5.
Yes.
It's not. But like I just want to say that you can see that everybody is fresh and still ready to talk, which shows that everybody is so interested, and you kept them alive. You kept them. You kept them. You made the talk so interesting that everybody is still. Even if you go for an hour more, they will be very happy about it. And finally, coming that, what do we take from here? Is that I understand the way, as the director spoke, the BNSS, the new criminal law, it is slowly sinking. And then as it sinks, there will be a lot of challenges for us, like we are talking about the framing of charge and the complainant to be heard, how they are going to be heard, what are the parameters. And I'm really glad that, it was so enlightening for us that it was not all about talking about the provisions which is there. The book which is already there, we can read it. But then as we all know, that the law, when it is legislated, it takes time to sink. And when it sinks, it has to be understood through the prisms of the precedents laid down by the highest court, which has got a binding effect under Article 141. And you have beautifully demonstrated that each point which is bothering us, how the Supreme Court has interpreted. And I think we leave this place as a better judicial officer because it is a new law. And as I think I just quote Justice Rishikesh Roy, when the new law was there, he said that after the introduction of the new law, we are all beginners now. Because we have studied CRPC, IPC, though there is a lot of parity on those two laws. But then this new law, there are a lot of grey areas. And once again, I'm very grateful. On behalf of all the judicial officers, we express our deep gratitude for making us understand those grey areas with the support of the precedents. The only little request which I can make is that if you can share this precedents with us. Thank you so much. Thank you so much.
A very good evening, everybody. First of all, great thanks to Sir Chandru. This is not my first time that I've attended his session. The orientation program was also attended by me. And when I heard that Sir is coming all the way from Madras, I could not have missed this chance of attending the refresher program again. So thank you very much, Sir. Thank you to the Judicial Academy for organizing this program. Thank you.
So there's one book that from the Academy would like to give you. The name of the book is History and Culture of the Khasi People. Now this is written by Dr. Hamlet Bare Angapkinta. He's a historian and he was the first Khasi to receive a PhD. He was also Padma Shri awardee, and this is his thesis. So we hope that you will learn and understand a little bit about us. Yeah. Kindly leave the textbooks behind, okay, the bare axe. Or if you're already out, you can leave it on the table outside, and the others you can leave on your seats if you're still inside the hall. Please return the books. Yeah, thank you.